Russo. Okay, so you guys are on for a pretrial conference. This matter is set for trial April the 24th. It's first on the calendar. But y'all had previously announced settlement, and now that seems to be trying to fall apart. And I think what I've got now are motions, dueling motions to enforce settlement. I assume the parties want to take that up first before we decide whether we need to spend our time doing a full pretrial conference. Is that fair, Mr. Carter, Mr. Russo?
Yes, Your Honor.
Okay. And did you guys request takedown?
I did not.
Okay.
I would like it to be taken down. Sorry if I missed the deadline for that.
Okay. I see that my court reporter is here, so someone must have requested takedown, and so I'll see if she's available.
Yes, Judge. I'm sorry, Judge. If I can chime in, it's the Martyr, it's the Jefferson and Martyr is the one that
Right.
Only.
Yeah.
Okay.
And so I'll see if, since she's already here, if it's if she's able to take that down. I would say the first step in that regard is if both of you, Mr. Carter and Mr. Russo, could email your particular information, email address, et cetera, in the chat or directly to Ione Taylor, so she'd have your information. And then I'll see if she's got time to accommodate that.
Judge, that's right.
Okay. And what is the announcement for the motions to enforce settlement, like in terms of time?
I believe mine will take 5 to 10 minutes.
I think that's about the same for me too.
Okay. Thank you. Devon Jefferson versus Abdi Hassan. Who do I have on behalf of Mr. Jefferson?
Drew Doland, Your Honor, and my colleague Dennis Swan is here too.
Good morning, Your Honor.
Cameron Hawkins, Mia Folks, and Attorney Nanya Roy for Defendant Martyr, Your Honor.
Okay. Hello. Thank you, Mr. Hawkins. Okay. So this case is on for a pretrial conference. There are dueling motions in limine as well. And I also note that at about 3 o'clock last night, we received a motion for continuance from the defendant and a motion for sanctions from the plaintiff. So does that cover the universe of what we need to address today?
I believe you received the response to our motion for sanctions last night from the defense.
Yeah, that's correct. It was the response to the motion that had been filed back in March by the plaintiff.
Gotcha. Okay. Thank you.
Okay.
Yes, that's correct.
Okay. And okay. And did y'all request, and y'all did request takedown? That's why Ms. Taylor is here, correct?
Yes, Your Honor.
Yes, ma'am.
Okay, excellent. New Falls Corporation versus Gold Leaf Transportation LLC.
Good morning, Your Honor. Hank Sue Smith here for the plaintiff, New Falls Corporation.
Okay.
Good morning, Your Honor. Vlad Bastian for the defendant.
Okay. What is the status of this case, Mr. Sue Smith? Is that right?
Yes, it is.
Okay.
Sue Smith, yes. We are requesting a charging order, and opposing counsel just entered the case, I think 2 days ago, and we had a conversation yesterday. And I think we can work through the various issues because it's effectively like a garnishment. And
yeah,
so
and thank you for addressing that. I was a little confused because I had not frequently had it where someone made a request for a charging order and then someone filed an answer and disputed. And so I was curious if the parties had an opportunity to work through that and figure out what to do with this.
Yeah. On my part, I just got in when I'm just trying to figure this out and as long as I've been practicing, this is one of the first ones. I understand the issues, but I think that it's one of those that if the parties have time to have more time with each other, we might be able to resolve this. So I know it's supposed to be on the trial for a week and a half from now. If we could be on the next trial calendar, I don't think it's a big thing. I don't even know the big amount that is in. So that's where we are, Jan.
So I don't. So my review of it is that it is appropriately on a trial calendar. It's not appropriately on a jury trial calendar, which is what's set to start on April the 24th.
We agree with you.
Yes. And so what I would probably recommend, because this wouldn't go on the 24th anyway, because that's a jury day for me. And so what I would suggest is perhaps we look, it wouldn't go to the end of May, but it would potentially go to the first week or two of May on a special set. So like we could just call you in for, whatever final hearing or bench trial or whatever procedural process we need to engage in with the parties to resolve it. And that would likely be probably the second week of May.
That sounds good, Your Honor.
Mr. Bastian, I know you got in late, but can you live
I
with that?
know. you can see the query in my eye. Yeah, we'll figure it out.
Okay, so we will excuse you, Mr. Sue Smith and Mr. Bastian, from today's hearing, and we will provide you with a notice of a hearing that will take place. As I said, I suspect it will be that second week of May. Okay.
Okay.
Thank you, Your Honor.
Thank you. City of Alpharetta versus 286.13 square feet of permanent easement. Do I have anybody here on that matter?
Good morning, Your Honor. Steve Drobny on behalf of defendant MERS as nominee for Rocket Mortgage.
I'm so glad you here appeared, because I was initially confused because obviously the case was closed by final order back on the 14th of March, but obviously then you guys appeared and filed essentially a demand for the funds that are in the court registry, since no one else had made that demand. Is that right, Mr. Drobny?
That's correct, Your Honor.
Okay. What is your educate me a little bit about? So I do this all the time with interpleaders, less frequently with in condemnations where no one has actually challenged the valuation and that sort of circumstance.
Correct, Your Honor. We're not challenging the valuation here. All the other defendants have been defaulted. So we'd request the opportunity just to submit a proposed order dispersing the funds to our client in accordance with the security deed.
That sounds reasonable to me. My only request, Mr. Drobny, is for these types of orders, I typically ask that you put a little more detail in them than you might otherwise, just in terms of your entitlement to them based on what was, and that way, when we go back and look, there will be one order that I will be able to sort of, if I ever need to, have some clear understanding of the nature of your role in the case and why you were justified to the funds. Okay.
Understood. Will do, Your Honor.
And if you'll submit that to Mr. Freehoff by email in Word format, we will get it on file for you.
Great. Thank you very much, Your Honor.
Thank you. Calvin Johnson versus Willis Peters. Do I have anyone here on behalf of Calvin Johnson and Willis Peters?
Judge, we haven't received anything from them in terms of.
I know, and there's a pending motion to withdraw for the plaintiff's counsel, but they've not been granted permission to withdraw, so they were still obligated to appear.
I'll check in South Georgia to see if they open these notices.
Thanks, and then thank you. And then the last matter, am I correct? Or the last matter on that page, that was the Crutchfield case that had resolved, correct? Okay. Cassandra Riley versus J.C. Davis Carpentry.
Yes, Your Honor.
Okay, let's walk through. Here's what I'm going to do. I'm going to walk
Your Honor,
through.
pardon me.
Sir?
Yes, I stepped in late after finishing up another matter. Jeffrey Yazinski for Bidland Credit. Pardon me, Jeff Yazinski on behalf of LVMV Funding versus Beezer, matter 373112.
Judge, sorry, I was having trouble unmuting. They have submitted a proposed order, and I believe we granted it as a result of no attorney's fees being requested, and the default was right. So I believe that matter has been resolved.
I hope so, because at least I didn't see it on my calendar for today, Mr. Yazinski. I appreciate you jumping in at the last minute, but I do believe that matter, that a proposed order was submitted that appeared to be appropriate and no evidence was required for any damage issue like attorney's fees. So we would have already signed it. We'll get it on file. So
the default judgment, is that what Your Honor's understanding was?
I don't know, because it's not on my calendar. Mr. Freehoff, perhaps you can connect with Mr. Yazinski offline and walk him through what the case is and what the status of it is.
I can do that.
Not now though, like offline.
Understood.
Thank you.
Okay.
Okay. So it is 9:45. Here's what I'm going to do. I'm going to take up the default motions and the Patel versus Bailey matters right now. I'm going to ask, so as not to take up unnecessary time if you find lawyers, so I let you go do other things while I'm busy working through these matters. I'm going to ask the parties, the attorneys involved in the Lapido case to return and be prepared at 10:15 to get started on that case. We'll work through those issues. And then at 10:45, I'm going to ask the Jefferson versus Marta individuals to return so that we'll have some time to spend with that case. You can log off and log back in. You can just mute and turn off your camera, whatever you want. You're not obligated to be here except until the Lapido parties at 10:15 and the Jefferson parties at 10:45. Thank you all for your attention, and I will be back with you shortly. And then we will go ahead and get it started. Mr. Morton with Cassandra Riley. Can you please walk me through the default motion?
Yes, Judge. Factually, what's going on here is my client, Miss Riley, who's also present here, if you need to hear from her, entered into a contract with the two defendants to do some repairs to her property. She paid them $25,011, and they essentially were unlicensed contractors. They didn't pull permits. They extensively didn't do anything of value for her. She demanded the money back. We have text messages if you want to see them where they promised to give her the money back. They even agreed to a payment plan, but in the end, they never made any of the payments to her. They just kept coming up with excuses. So we filed this complaint. Procedurally, both the defendants were served on February the 24th. The 30 days would have been March the 27th. The additional 15 days would have been April 11th, just a couple days ago. We got the court's order. We filed our motion for default yesterday. I have a file stamp copy showing yesterday's date at 8:37 a.m. So it was filed. We've submitted.
In just opening it this morning, Mr. Morton, it does appear that I do have it now. So
yeah, so we are asking for the court to award us the $25,011 that was paid to the opposing side. And as I said, which they've agreed to pay back, we just haven't gotten any money. I'm also asking for attorney's fees in the amount of $918.75. Where I come up with that is that's 3.5 hours of work up to today. I'm charging Miss Riley $262.50 an hour. I've been licensed to practice law in the state of Georgia since 2004. No discipline on that license. I believe $262.50 an hour is a reasonable hourly rate in the metro Atlanta area. So again, 3.5 hours at the $262.50 is $918.75. Also asking for the filing fees, which I believe is around $314, which is in the proposed order that's sent to your staff attorney.
Okay, and Mr. Morton, let me just applaud you on the reasonableness of your attorney's fees especially for an individual like Miss Riley. Sometimes it can be hard to retain good counsel to do that work for them. So I appreciate that. It does appear I had reviewed the file as well, and everything that you represented regarding the dates of service and the date in which the defendants went into default, and that April the 11th was the date past which they would not be able to open default as a matter of right. And it does appear that the underlying damages are liquidated, and that there is a basis for recovery based on your attorney's fees and costs. And so I will go ahead and enter that default judgment, and we will take a look at the order that you've submitted. And assuming that everything's in line with, what you've represented and the dollar numbers are the same, we will go ahead and get that on file for you today. Okay.
If you need me, thank you. If you need me to make any changes to the order or get you anything else, just let me know.
I will. Thank you, Mr. Morton.
All right, may we be excused?
Yes.
Have a good day, everybody.
You too. Okay. Winthrop Homeowners Association versus Sam Wynn and Helen Tran.
Good morning, Your Honor.
Hi, Ms. Brock. So before we started, I was telling you, I had looked at the file, and it's clear to me that Mr. Wynn is in default. What was less clear to me is I don't know that it's fair to say that Ms. Tran isn't in default. It's that there's no evidence in the file indicating when that request for waiver was sent to her. So I can't determine if she is in default.
Right, I can tell you, I was just looking back in my notes and it appears that we sent the waiver on March 7th to her.
Yeah, I thought that might be the case because the motion that you had filed indicated that she had received the summons and complaint on the 8th. And then it looks like she actually signed the waiver that you submitted. And so for that reason, I'm going to have you walk me through the default on Mr. Nguyen. And I'm happy to, based on what my review of the file and what I believe you'll present, give you the default judgment on Mr. Nguyen. But as to Ms. Tran, I think that it would be premature and that we need to wait the additional time, because if it was provided, I think you said on March the 7th.
Yes, Your Honor.
Yeah, my best math, and that's excluding that there are 31 days and whatever, but just doing some quick, it would be what, May the 7th-ish. And so we would want to make sure that we allow that. And then I believe that the additional 15 days would still apply to that circumstance. And so we'd be looking at mid to late May before there would be an appropriate entry of a default judgment as to Ms. Tran.
Yes, Your Honor. I believe so.
Okay, so walk me through Mr. Nguyen real quickly. And have you submitted a proposed order on him?
I have. Well,
okay.
For both parties.
It was a joint. Okay. So what I'll do is, assuming that I'm going to grant Mr. Nguyen's default judgment, if you will resubmit in Word format to Mr. Freehoff's email address, a default judgment as to Mr. Nguyen only, then we'll go from there. Go ahead, Ms. Brock.
Yes, Ron, we filed this complaint for unpaid homeowners assessments and other miscellaneous charges on December 29th, 2022. Mr. Nguyen was served with the summons and complaint February 16th, 2023. And as we've discussed, Ms. Tran waived service of the summons and complaint on March 8th. I filed the default motion this week. I provided affidavit of non-military service and a notice of intention to introduce business records with the certification and authentication of the ledger from the property manager.
I saw that.
Jackson. And the assessments, we're asking for $2,210 from April 30th, 2019 to February 1st, 2023. We're asking for accelerated assessment authorized by the declaration up to the end of this year in the amount of $250. The miscellaneous charges, we're asking for $165. Interest so far is $496.60. And the attorney fees are $4,679. And that is due to, there was an enforcement issue in this matter going back to 2021. And there's been several years worth of work on that, getting their covenant violations resolved.
So tell me how that works in terms of, is that something that by operation of the declaration is rolled over into assessment obligation by the homeowners, or?
The declaration allows for the collection of reasonable attorney fees actually incurred, both on assessment, enforcement, and also covenant violations.
Okay.
So going back to 2021, July 20th, 2021, the file was opened as an enforcement matter with resolving the covenant violations. And then it was turned back over to myself back in November as just because all of the violations had been resolved, and then we were set back on the collections.
Okay. And then my next question, and this is just for my own benefit. I assume that the homeowners here, Mr. Nguyen and Ms. Tran, are joint homeowners, joint owners of that property?
Yes, Your Honor.
And so does that mean that they are jointly and severally liable for the HOA assessments?
Yes, Your Honor.
Okay. So I think that the explanation regarding the attorney's fees and the prior enforcement matter, it may actually answer a question I had yesterday when I was looking at the file, which was why the proposed order was only as to liability and not as to damages. Typically, we just have the attorney show up and say, here are the assessments and these are my fees. And so I think because of that enforcement issue, not to imply that they wouldn't otherwise be recoverable, but that I would want more information about them. I think it would make sense to go ahead and enter the default judgment as to Mr. Nguyen, who is clearly in default based on the date of service and the amount of time that has passed, as to liability, and then to wait the appropriate amount of time and see if Ms. Tran answers. If she does not, and we have an additional default hearing as to Ms. Tran's default, then what I would expect at that time is at the same time to have the actual damages hearing, and I would enter any award of damages that were appropriate based on the default as to both Mr. Nguyen and Ms. Tran at that time. Can you live with that, Ms. Brock?
Yes, Your Honor, I can.
Okay. Okay, so if you'll do me a favor and, as I said, submit a proposed order that only addresses Mr. Nguyen and only enters default judgment as to liability, then we will notice the hearing for an appropriate time after the time will have passed for Ms. Nguyen to see if she files an answer. And at that time, whatever hearing we have would also be a damages hearing. If Ms. Tran does file an answer, then we will simply separately notice for you a damages hearing regarding Mr. Nguyen. Okay? Okay. Thank you, Ms. Brock. Anything else?
No, Your Honor, may I be dismissed?
Yes, thank you. Okay. Patel and Bailey. Mr. Chabda, Mr. Thompson, are you back with me?
Yes, Your Honor.
Okay,
Yes, Your Honor, I'm
excellent.
here.
Thank you. Okay, so I am going to tell you what I remember about this case, and then I'm going to let you guys walk me through. Well, let me say this. I have an independent memory of it, but I've also read the parties' briefing up to this point, and I've gone back and refamiliarized myself with the general facts of the record in this case and also in the prior case. So what I believe I know, and y'all will have an opportunity to correct me if I'm wrong, is that Mr. Patel was a tenant at a commercial building owned by Mr. Bailey, and that as part of that lease agreement, Mr. Patel had an option to purchase. There was a breakdown of that relationship at some point. And ultimately, Mr. Bailey took the position that the option to purchase was no longer feasible, wasn't an option for Mr. Patel. Ultimately, part of the dispute that was before me at that time was that Mr. Patel had been paying for a number of years on that property that was supposed to go towards an inevitable purchase price if he had exercised his option. So what I understand to be the resolution of that case was the case was getting ready to be set for trial. I had, I think, ruled on summary judgments in that I had denied all of them, except perhaps I had entered some sort of injunctive relief in favor of Mr. Patel, and it was as to further dispossessory actions in that case. Beyond that, the parties engaged in a mediation, settled the case in broad strokes with an agreement to for the parties to get appraisals and then come to an agreement about what the purchase price would be with a credit to Mr. Patel for the amount of money that he'd previously paid towards the option under the original lease agreement. That didn't work out because then the parties ended up with some wildly divergent opinions about the value of the property. And I think that's what led to this lawsuit. And then in response to this lawsuit, Mr. Bailey asserted certain counterclaims, and also one of which was a dispossessory either action or at least notice that he intended to pursue dispossessory remedies. So that's where I think we are right now. If anything I've just said is wrong, or if you need to tell me more information that I don't know, please do. Mr. Chavda, if you will, well, let me say this one more thing. My understanding is that the declaratory judgment, and there was a count 5 in the counterclaim for additional damages, were voluntarily withdrawn by Mr. Bailey. Thank you, Mr. Thompson. And that where we currently are is there are 5 counts: dispossessory, distress, demand for rent, attorney's fees, and breach of contract that are currently pending. And what I was a little less clear on, Mr. Chavda, is your motion to dismiss still continues to be as to all the remaining counterclaims. Is that right?
That's correct. And I've renewed the one for the amended counterclaim, the breach of contract that Mr. Thompson just recently filed.
And that was why I wanted to clarify, because for a moment when I looked at the docket, it looked as if perhaps you were only proceeding on that one. But I wanted to clarify it's as to all of them.
It is.
In broad strokes, the basic argument from Mr. Patel is that all of this was litigated in the prior action. They are barred by res judicata from relitigating it now. And I understand generally Mr. Bailey's argument to be that his complaints now are about things that occurred after the other lawsuit had ended, and therefore not barred by res judicata. So that's what I think I understand about your case, Mr. Chavda. It's your motion. Go ahead, sir.
Thank you, Your Honor. Thank you for reciting the facts. I'll just discuss some of the relevant procedural history. So in the July 2020 order that when Your Honor denied summary judgment, there were 2 essential takeaways from that order. One, that it was undisputed that the lease was terminated. And number 2, as you had mentioned, the court granted Mr. Patel's motion for injunctive relief. Essentially that Mr. Patel gets to remain on the property as long as he continues to make the 1703 payments on a timely basis. And that would Mr. Bailey would not be able to send any sort of dispossessory notices or file any other additional actions. And if you recall, Your Honor, in March 2021, Mr. Breedlove, on behalf of Mr. Bailey at that time, filed a motion for writ of possession because Mr. Bailey was under the incorrect assumption that Mr. Patel had stopped making payments, which was not the case. We filed in turn a motion for contempt. You said this could have been avoided by a phone call, so pick up the phone and talk to each other. So then we were on the trial calendar and we tried to set up mediation. We finally did in December, as you stated, and the resulting mediated settlement agreement that was valid and binding. Mr. Bailey was there, Mr. Patel was there. We spent 7 hours that day going through it, and Mr. Patel got the exclusive right to purchase the property based on those 3 appraisals, which would essentially be the average would be the fair market value of the property. We got the 3. Mr. Patel got his was in the median was 567. The independent was 380, and Mr. Bailey's then thereafter was 1.8 million. We couldn't come to a resolution on it. I talked to Mr. Breedlove that day when we received the appraisal from him, and my conversation with Mr. Breedlove was, "Hey, we can figure this out. We don't need court intervention just yet. Let's figure it out amongst ourselves." If you remember, Miss Mowry was there as well, and so she and I both attempted to reach out to Mr. Breedlove on numerous occasions throughout our remaining time at the previous firm, and then the next attorney took over. But we had no idea that Mr. Breedlove didn't represent Mr. Bailey anymore, or what the status was at that point in time. And then once Mr. Thompson entered the picture, he sent a dispossessory demand letter to Mr. Patel directly, and Mr. Patel re-engaged me and asked me to resolve this issue. And so essentially, Mr. Thompson and I spoke. We tried to resolve it. It didn't work out initially, and then I filed this action. We discussed again mediation. So we went to formal mediation in January in this case again, and that was unsuccessful as well. But it's important to note that Mr. Patel has been making these 1705 payments up until today. The original option to purchase was for $296,000 on the property. He has today he's paid $365,000. and that he has nothing to show for it. And we can't rely on Mr. Bailey to make those payments. So Mr. Patel's continuing to make those payments. If he stops making them, bank could foreclose on the property and we've got nothing essentially. So, and it's essentially deja vu, and the law doesn't allow for that. Res judicata prevents relitigation for, and if it's the, any claims that have already been adjudicated or could have been at that point in time, which all of their claims essentially have that count one for dispossessory, distress, demand for rent, attorney's fees, and breach of contract, right? Going backwards, the breach of contract that Mr. Thompson just filed essentially talks about how Mr. Patel's engaged in some sort of illegal activity. Mr. Patel, the search warrant that was included in the—
Well, let me stop you there. So I understand why Mr. Patel would take offense. I understand why Mr. Bailey would raise it. Those are things that are wildly outside the four corners of the complaint, or the counterclaim, I should say. But I will say this, one thing within the constriction, the construct of the motion to dismiss and the pleading itself, it does seem, I am a little confused by the fact that Mr. Bailey seems to be asserting contract remedies and also non-contract remedies, and that claim particularly attempts to invoke a contract term that has been void since 2019, right? The contract terminated in 2019, and the parties have been operating without a contract since that time, so.
Right. And I agree with you. And in addition, even the other counts, the dispossessory and distress, they're claiming essentially that the consent's not valid, that the mediated settlement agreement's not valid, but they're still going forward with, there's no breach by Mr. Patel of the consent agreement. He's been making the payments. We reached out numerous times to try to close on the property. And the only issue the issue that Mr. Patel has is that 1.8 million was unsubstantiated. It just didn't, even the entire appraisal document doesn't actually show what the basis was for the comps that were in the area, whereas the other two do, right? And so the easy option back then, which Mr. Breedlove and I spoke about initially, was let's get new appraisals done. That's the only thing at issue here, right? But then that obviously didn't work out as well. And then going through the other part of res judicata, it's the same parties. The lease is terminated at this point, right? In 2019, it was already it was as the court correctly stated. So just skipping over the breach of contract, where we're asking for a dismissal of all the claims, and in addition, we asked previously in the underlying case for a TRO and injunctive relief, and we're asking for that again as well, to prevent Mr. Bailey from trying to retake the property while this case is now pending, because every time there's a dispossessory threat, despite the attorney's fees, which are unnecessary at this point, Mr. Patel has been paying that $1,705 every month. We've provided that documentation to Mr. Thompson and to the court. And so we're asking that there be an injunction effective through the adjudication of this case as well.
Okay. Anything else, Mr. Patel? I'm sorry, Mr. Chavda.
Just the attorney's fees as well. That's in there. I don't. I can go through it, but I've got it in there as well.
I did see the 9/15/14 request, so I am aware of it, and it's not something that I would take up today, depending on substantively whether I would take it up at all. But if I did, I still wouldn't reach it today. So, but,
sure.
But I'm aware of it, Mr. Chavda. Go ahead. Anything else?
No, Your Honor. Thank you.
Okay, thank you, Mr. Thompson.
Thank you, Your Honor. Excuse me. Let me first say that I understand that this matter has a long and convoluted history that has seen a number of counsel on both sides. And I will say that since my entry into the case, my communications with Mr. Chavda, I think, have been somewhat productive, even though we've reached log jams at certain points in time. But as I review the case, it is a bit curious as to how it became so complicated. Because I think if you strip away some of the noise, you're left with a number of incontroverted facts. First and foremost, the lease has terminated. No one disputes that. The lease also had a holdover tenant clause, which was intended to deal with a situation where a tenant remains in the property after the lease expires. And so under that clause, Mr. Patel is required to pay 150% of the rent that was set forth in the lease. So as opposed to the $1,705, the monthly payment should have been $2,257.50. That's not been paid. That's not been paid at any point in time since June 21st of 2022.
Right, but I think where forgive me for interrupting you, Mr. Thompson, is the issue is perhaps it was a failing on the part of Mr. Bailey's attorney in the prior matter to raise that issue, but in the prior case, we were dealing with post termination of the lease. We were dealing with a universe in which Mr. Patel was already a holdover tenant, and everybody agreed, no one challenged or argued that the 17 whatever wasn't sufficient. And so setting aside the issue, assuming that the holdover clause would be applicable here because Mr. Patel is a holdover tenant, I think that's the part that Mr. Chavda is urging, is that even if you're right, that should have been raised in the prior action, because in the prior action, Mr. Patel was already a holdover tenant, but it wasn't. So how do we deal with that, Mr. Thompson?
Well, if the position is that we're operating under what's been called the mediated settlement agreement, it's our position that unfortunately is also unenforceable, because it doesn't address all of the material terms that are necessary in order to have a meeting of the minds on the issues that are being raised in this dispute. And I'm talking about from the beginning. So for instance, it doesn't differentiate between rent payments and option payments. It doesn't say what happens in the event the parties get appraisals that are not reliable. With respect to the 3 appraisals, as your honor has noted, they were widely disparate. Mr. Bailey got a third-party expert to review the lowest appraisal, and that expert has determined that that appraisal used the wrong methodology and it was unreliable. So the parties don't have any guidance whatsoever as to how to deal with that issue. And so because the material terms in the confidential mediation agreement upon which all of this post-lease activity is premised, because that document is unenforceable, then the question then becomes, what governs the parties' rights and obligations at this point? And so if that is not governing, then I think we're left with what the lease said, and the lease itself contemplated holdover tenant. So our position is that the mediated settlement agreement did not resolve the matter. It actually made it a bit more complicated.
Okay, so I don't disagree with your assessment, Mr. Thompson. It's just that the issue that I have is, to the extent that Mr. Bailey is attempting to assert a dispossessory claim, to the extent that it is premised on this idea that Mr. Patel either didn't pay rent, which undisputed evidence seems to be that he did, that he has made a payment each month based on prior orders of the court and or agreements of the parties. And to the extent that, or to the extent that the argument for Mr. Bailey is that, but the amount of rent he should have paid was higher under the holdover tenant provisions of the lease, that matter was already litigated in the prior case, right? Like the applicability and requirements of the holdover was already litigated. And so to the extent that the dispossessory action is based on the holdover clause of the lease agreement, that matter, I think, would be barred by res judicata and would not be able to be pursued. Now, to the extent that outside of that, in terms of tenant sufferance or whatever theory, Mr. Bailey is technically still the owner of the property, and Mr. Patel is technically still occupying the property in some legal capacity. That might be a conversation we could have, but I'm not sure I understand what what is the basis for the dispossessory? And I think I understand the basis of the dispossessory to be that under the terms of the holdover clause, he owes more money than he's been paying. And if that's the basis, then I think that claim would be barred by res judicata and would be appropriate.
I'm sorry.
Go ahead.
No, it's not just that, Your Honor. The fact remains that he's a tenant at sufferance. And as such, Mr. Bailey is entitled to possession of the property upon demand. I mean, we're either operating under the lease or we are not. The lease says disputes should be resolved pursuant to the lease. Now, if the court accepts our position that the mediated settlement agreement is invalid, is unenforceable, then we have no choice but to either default back to the lease or to the statutory remedies. And as a tenant at sufferance, the demand for possession was sent back in December. And to your point, Mr. Bailey still owns the property. Mr. Patel is still a tenant. There's no lease in place. So we would contend that whether under the lease or not under the lease, Mr. Bailey is entitled to possession.
Except that, and this is where I get stuck, and this is why the procedural background of the case is so, I think, important to understand, is that at the time that the settlement agreement, which I understand on behalf of Mr. Bailey, you urge is not enforceable or not a valid agreement. But at the time of the settlement agreement, the purpose of that settlement agreement was to, Mr. Bailey was agreeing that he was no longer going to possess the property, no longer going to have a right to possess the property because he was going to sell it to Mr. Patel. And so how do we reconcile that with this new asserted claim by Mr. Bailey that I still own the property and he's still required to pay me? When at least an argument could be made that the reason that this all hasn't been resolved is because of Mr. Bailey's insistence on this $1.8 million appraisal.
Right. We would, in response to your question, Your Honor, we would say that Mr. Bailey's entitled to possession, again, just by virtue of the fact that he's made demand on a holdover tenant. However, beyond that, the actual mediated settlement agreement contemplated that the transaction may not close. It said if the plaintiff declined to close, then certain things would happen. If the defendant declined to close, then certain things would happen. Now, as we sit here today, Mr. Chavda and I are having discussions regarding the reappraisal approach, but it's our position that Mr. Bailey's not obligated to that. Again, because the mediated settlement agreement itself is not enforceable. We can have those discussions, and if we come to resolution as a result of those discussions, fine, but we don't believe he's obligated to do that. We don't believe he's obligated to sell. By statute, the landlord is entitled to payment during the tenant's possession. To compute that rent, the landlord would have to look at the lease to determine. And when we look at the lease, again, the holdover tenant clause has some relevance. And this is why I said in the beginning, it's I think of a simple case that's been made a bit more complicated than it probably needs to be. It's a clear-cut case of a tenant at sufferance and a demand being made upon that tenant at sufferance. With respect to the appraisals, the mediated settlement agreement, the consent order, all of that happened after the conclusion of the previous litigation. So these are matters that have arisen since then and could not possibly have been raised at that previous previous litigation.
Okay, Mr. Thompson, answer this one question for me. I think I understood you to be saying that the basis for the Mr. Patel hasn't paid rent and owes this $28,000-ish is that that a greater sum of money was owed than the $1,700 that he's been paying per month. And what I hear Mr. Chavda saying is there's evident, I don't understand how both of those things could be true. Either Mr. Patel has been paying rent or he hasn't been paying rent. It is Mr. Bailey's position that he hasn't been paying rent. And if so, how do you justify that? Or is it that he's been paying an insufficient amount of rent?
Great question, Your Honor. Initially, when I engaged, I spoke with Mr. Chavda, and for whatever reason, the statements that the bank was sending to Mr. Bailey reflected that no payments were being made. He was getting zero balance statements for several months in the year of 2022, for instance. Mr. Chavda provided canceled checks that showed that the payments were continuing to be made. And we don't dispute that those checks are, we have no reason to think that they're not what they appear to be. So that is an issue that we are sorting out with the bank as to if those payments were being made on a timely basis during 2022, why was zero payment being reflected on the statements that Mr. Bailey was receiving? We will sort that out. However, again, in a situation where the mediated settlement agreement is not enforceable, and in a situation where the lease itself contemplated a holdover tenant, the amount that should be paid is $2257.50 and not $1705. And that means that each time Mr. Patel does not pay that, it is a new breach. It became a breach in February of 2022. It became a breach in March of 2022. And, I honestly think that the holdover amount is what should have gone into the previous understanding. I think that would have, cleared up some of the misunderstanding, particularly regarding his rent payments, the option payments, and what have you. But the 1705 is what was being dealt with when the parties clearly agreed that if a tenant became a tenant at sufferance, then this is the amount that would be payable.
Okay. Mr. Thompson, I am not familiar with a distress warrant. Can you tell me what that is?
A distress warrant is when there is under, I think the statute is OCGA 44-7-75. Let me make sure I gave you the right. Yeah, OCGA 44-7-75 is when a tenant is in possession of premises and in breach of the lease and is looking to remove property from those premises. Then that gives the landlord an additional remedy to come back on those premises and take possession.
Okay.
But I would also add that because he's a tenant at sufferance, the issue of payment of rent is not really relevant. I mean, we have alternative claims and the expiration of the lease is sufficient. We would be entitled to possession. Mr. Patel would be entitled to try to enforce the option. And as a result of that, we believe that the possession would be in our favor. The last thing I will mention about the distress, Your Honor, is that it entitles the landlord to put a lien on the tenant's personal property as security for the unpaid rent. And if the unpaid rent claim fails, that claim will fall as well.
Okay. Mr. Thompson, anything else you want to add before I hear from Mr. Chavda? Because it's his motion, so I'm going to let him have the last word.
I do not believe so, Your Honor.
Okay. Thank you, Mr. Thompson. Mr. Chavda?
Thank you. I agree with certain points that Mr. Thompson made, specifically that, he and I had a good rapport about trying to resolve this thing when he first got into the case. But one thing that he just mentioned was that the additional payment, the $2,500 or whatever that Mr. Patel is allegedly supposed to make, should have gone into the prior understanding. And that goes back to my original point of res judicata being, if there should have been an adjudication on the merits, or is a point that should have been brought up in a prior action, that's when it should have been brought up. And that's what he just mentioned. He's talking about the simplicity of this case. It is very simple. there was a consent judgment and a mediated settlement agreement. That's what resulted in the 2-year-long litigation that we had. And we can't talk about it, and any of the tenant net sufferance and any other statutory claims were only premised upon the underlying lease, which was terminated. And the fact of the matter is that Mr. Bailey can't stick his head in the sand for that many months and then come up and say, hey, he wasn't making payments and I'm going to kick him out. That's all I have, Your Honor.
Okay, thank you, Mr. Chapta. Okay, so I think we clearly have some work to do on the underlying petition and the defenses that I am hearing from Mr. Bailey in terms of whether that was a valid agreement that can be enforced and whether there was a meeting of the minds and all of those issues. What I don't think we can do is revisit the terms of the contract, the lease agreement that was previously in effect, that by everybody agrees was adjudicated fully in the prior case, up to and including a consent. I ruled on summary judgments. I entered an injunctive order, and the parties then entered into a substantive agreement to resolve the case. Now, whether that substantive agreement can be enforced by its terms, whether it should be enforced, which I understand is what Mr. Bailey is requesting, whether there's extra work that needs to be done, the parties can, that's going to be what work we need to attend to. But I tend to agree with Mr. Patel here that the causes of action that are asserted in the counterclaim by Mr. Bailey are barred by res judicata because they're asking this court to revisit issues associated with the lease, which issues were fully adjudicated or, importantly, could have been fully adjudicated in the prior case. And that's the standard for res judicata. So I am going to grant Mr. Patel's motion to dismiss the counterclaims that were asserted. I'm going to grant them with prejudice with one caveat, and that is there might be a universe. I'm not saying substantively I would allow recovery on it. I'm not prejudging that issue. But there might be a universe, given that Mr. Bailey still owns the property and that Mr. Patel is still possessing it. There might be a universe in which Mr. Bailey could attempt to assert entitlement to possession that is not based on the lease, but is based on the physical possession of the property by Mr. Patel, despite the fact that it's owned. I'm not prejudging that issue, but I will say this. Counts 2, 3, 6, and 7 are dismissed with prejudice. Count 1 for dispossessory is dismissed without prejudice if Mr. Bailey wants to attempt to reassert some sort of dispossessory that is based on something that doesn't have to do with the contract. I don't know if he can. I'm not prejudging that, but I feel like it would only be fair to leave that open. So that's going to be my ruling on the motion to dismiss. I am going to leave open. I'm not saying that I will award attorney's fees under the 91514 request that was made by Mr. Patel, but I am going to leave that issue open. And the only matter that also remains open is this issue as to the injunction for dispossessory. And so this is what I'm going to say. What I'm going to say is Mr. Bailey at this point knows everything that he needs to know in terms of if he that Mr. Patel is in possession of the property and that he owns the property, and whether or not he believes there is a non-lease related basis for him to attempt to assert dispossessory. And so what I will say is if Mr. Bailey wishes to amend the counterclaim or otherwise reassert a claim for dispossessory that is not associated with the lease, assuming that he can or chooses to do so, I'll give him 30 days to do that. And if Mr. Bailey does not, and if he does file a dispossessory, then that's going to require the court's attention in a more immediate sense, right? Than any other matters that are in the case. If he does file a dispossessory, then we will take that up as quickly as possible after the filing of it. If he does not file a dispossessory, or if upon taking that up, the court also denies or dismisses the dispossessory, right, as not being legally appropriate, then the court will enter an injunction prohibiting Mr. Bailey from engaging in any further dispossessory efforts as to this property until the resolution of the ownership issue. Is everybody clear on what I've just said? Even if you might disagree with it, probably both of you do, but Mr. Chavda?
Yes, Your Honor, I'm clear.
Okay, Mr. Thompson?
I do have a couple of questions, Your Honor.
Sure.
With regard to count 7, the breach of contract, am I understanding correctly that that's being dismissed with prejudice because it is premised on the lease's prohibition of using the premises for illegal purposes?
It's based on the fact that the lease is no longer in effect. And so Mr. Bailey can't rely on it to assert a breach of contract claim because the contract terminated in 2019. And so he can't rely on its, I mean, it's one thing to try to rely on a holdover provision, right? But he can't rely on a term of the contract that's no longer in effect and that was fully litigated back in the day. Now, there might be other ways or theories that he might pursue, but the reason I'm dismissing it is because that contract is no longer in effect, and everybody agrees that that contract is no longer in effect.
Understood, Your Honor. And one other question, I guess, in the nature of a request, under OCGA 44-7-75, where the issue of possession cannot be determined within 2 weeks, the statute requires the rent to be paid into the registry of the court, and then in turn paid to Mr. Bailey as it becomes due. Can we have that also included in your order since Mr. Patel is going to continue possession of the property, at least in the near term, and presumably paying rent?
So I don't have an objection generally to some provision that requires Mr. Patel to continue paying rent, but here's the problem that I have. My recollection is that Mr. Patel was paying that rent directly to a banking institution that was an account held by Mr. Bailey, and that failing to make that payment, paying it into the registry and delaying its being provided to the banking institution could potentially risk the property being foreclosed upon. And so that would be my concern. Now, if the parties want to engage in some effort to resolve that issue, then they can. But my understanding all along was Mr. Patel has, in fairness, I know Mr. Bailey probably disputes that, but Mr. Patel has never objected to his obligation to pay rent. But that one concern about paying it directly to Mr. Bailey or paying it into the registry of the court is that Mr. Patel would then be relying upon Mr. Bailey to take those funds and pay it to the bank to avoid a foreclosure on the outstanding line of credit that is secured, at least in part, by that building. And so that's why we had not previously had the funds paid into the registry, but had continued to have them paid to the banking institution. The parties want to try to work that out. I have no objection to that issue and to requiring it to be paid into the registry. But just by way of background, Mr. Thompson, that was something that we had looked at, and that's why we hadn't done it that way in the prior case.
No, I understand. And then I also understand that the payments to the bank, directly to the bank, were done at Mr. Bailey's suggestion. And so I get it. Perhaps what should happen, I guess, you know, in an effort to comply with the statute, Mr. Chavda and I can have this discussion, and we can keep Your Honor apprised of what does or does not come out of that discussion.
Okay, please do. And I will say, in fairness, my lack of familiarity with the distress claim that you're asserting and some remedies that you're attempting to assert under it, I think it probably would be fair to leave that one as a dismissal without prejudice, simply because if you wish to bring it up in association with a subsequent dispossessory action that is not lease adjacent, right? That is not barred by res judicata, then in fairness, I think you should be able to do so. And so just to clarify that, counts 1 and 2 are dismissed without prejudice. Counts 3, 6, and 7 are dismissed with prejudice. And Mr. Bailey has 30 days to amend counts 1 and 2 to assert claims that are not, or to assert new claims, or to amend the old ones to assert claims that are not associated with the lease. And if he fails to do so, then the court will enter an injunction prohibiting Mr. Bailey from further dispossessory actions while we litigate the underlying contract settlement agreement that is at issue in the case. Okay?
Your Honor, just one last thing. Go ahead, Mr. Thompson.
Yes, thank you. I was going to ask if it was possible for the court to issue a certificate of immediate review, not saying that we would act on it, but just for purposes of keeping all options open as we review the court's order here.
I'm usually pretty free with certificates of immediate review, Mr. Thompson, but given the nature of the delay in this case and the fact that the delay, there's sort of I don't think that these issues rise to the level of requiring a certificate, and I'm concerned about the continued delay. We all have some time to think about it, because although I'm telling you what my ruling is now, I'm going to ask Mr. Chavda to draft a proposed order, to run it past you, and to submit it to me so that I can review it and make sure that I believe it accurately reflects the ruling that I'm giving you now. And so we've probably got a week or better before I would actually enter a judgment, which gives you some time, and you're free to more formally make a request for a certificate at the time or immediately after that order is entered, and I will give it some thought. But just in fairness to you, I will tell you that I would have some concerns about it, but that doesn't mean that I'm definitely saying no.
Understood, Your Honor, and thank you.
Mr. Chavda, did you have something else?
Yes, Your Honor, just one last thing. Can we just, in the order, can we add, or whenever we draft it up, that this court will have exclusive jurisdiction for any dispossessory actions as well, that they won't go file somewhere else in MAG court or anything else when it comes to this particular property?
That seems reasonable, Mr. Thompson. Any objection?
No objection. We're fine with that.
Okay, then yes, please include that, Mr. Chavda.
Thank you. Thank you, Judge.
So today is Thursday. If you could get me that proposed order by next Thursday.
Absolutely.
Anytime sooner than that's fine as well. But if you'll get me that, I will get it on file. To be clear, to the extent that Mr. Thompson has issues with the order, I'm not asking you to relitigate the presentations that you've made to me. I've ruled, but I do ask the parties to work together to make sure that both parties are in agreement that what the order says that is being presented to me accurately reflects what I said here today. And so I'll ask y'all to do that. Submit it to Mr. Freehoff in Word form by email no later than Thursday of next week, and then we'll get it on file. Okay?
Thank you, Judge. May we be excused?
Your Honor.
Yes, thank you both. Have a good day.
Thank you, you too.
You too.
Okay, we are now going to take up the Lapido matter, but if you kind gentlemen would give me a moment to get some more coffee before we get started, I'd appreciate it. It is 10:37. We'll get started at about 10:40, so just a few minutes.
All right. Sounds good. Thank you, Your Honor.
Are the parties who were requesting takedown of the court reporter still on the call?
Yes, this is David Carter for Dr. Lapido. I requested takedown. Mr. Russo has also requested takedown. We have sent an email
To Ms. Taylor?
to Ms. Taylor to that effect.
Okay, and that's what I was going to ask you to do if you had not already done that. So if you have already emailed her, she will set that contract up using her Square account, and that should be underway before we get into your case. All right, I just was asked by the judge to make sure you had contacted her. All right, thank you.
Thank you.
Okay. Mr. Russo, Mr. Carter.
Yes, Your Honor.
Excellent. And also,
Yes,
I guess, Mr. Mays and Mr. Kiko Pratt. Is that right? Okay. Gang's all here.
Thank you.
Were you able to connect with Ms. Taylor? Yes, it looks like you were. Hi,
Yes,
Ms.
Your Honor.
Taylor. Are you ready to proceed?
Yes, Your Honor.
Ms. Taylor, are you ready?
Oh, I am. Thank you, Judge. Yes.
Thank you. Okay, this is going to be a hearing in the matter of Rachel Lapido, L-A-P-I-D-O-T. Apologies if I'm not pronouncing that correctly. Versus Scott Honan et al. Case number 2021 CV 351-890. I will start by noting that this matter is actually set for trial on April the 24th. It was previously set for trial in January of this year, but the parties reached out to the court and notified us that the parties had mediated the case to a settlement, and that could they please be excused from the trial calendar, which we graciously agreed to do, and the parties went on about their way to attempt to reduce their settlement to final settlement documents. That seems to have fallen apart, and so now we are here in addition to today being set for the pretrial conference in advance of the trial on April the 24th. We are also set, we are also have before us a motion to enforce settlement that was filed by Mr. Carter on behalf of Ms. Lapido, and a response, objection, and also cross motion to enforce settlement that was filed by Mr. Honan et al. My basic understanding of the fundamental dispute between the parties is that Mr. Honan was to personally guarantee one of the largest pieces of financial portions of the settlement payment. And where the settlement broke down was the nature and extent to which that personal guarantee was secured to some asset. Specifically, there seems to be a disagreement about whether or not it would be tied to a building that was part of the investment strategy that brought us all here in the first place, that Mr. Honan, I think I understand, does not actually own. And so therefore it would be somewhat difficult for him to provide a security as to it. But I think that's what I understand to be the fundamental dispute between the parties, and that the larger issue of the dollar amount, the schedule of payments, et cetera, are not in dispute. But that whether or not that payment is secured to an actual asset as opposed to just a promissory note or a personal guarantee from Mr. Honan is what I understand to be the fundamental dispute. Mr. Carter?
Yes, Your Honor, thank you. I believe a settlement was reached on December 22nd of 2022. The security of the promissory note you mentioned was crucial to us all day. The premise of our entire case is that Mr. Honan and his agents and his other businesses have repeatedly and chronically misled Dr. Lapido. There is no way that we can simply rely on Mr. Honan's word that he was going to make good on a promissory note in any manner whatsoever. What we negotiated for was some way of underwriting Mr. Honan's personal guarantee and then have to have the promissory note secured by some piece of property. At the end of mediation, once we had reached this agreement, Judge Brasher told me to put this into a term sheet, which I did. Mr. Brasher then looked at the term sheet, confirmed it was what the deal was, and was present with me when I pressed the send button on that email on December 22nd at 6:10 p.m. After that, we walked into the other room to shake hands with opposing counsel and Mr. Honan, at which point I said, hey guys, I've just sent a term sheet. Please review it when you have a chance. Let me know if you have any objection to it. No objection was ever given at any time. Judge Brasher was copied on that email along with Ms. Russo and Mr. Mays. Fast forward to January 3rd, we've received word from Mr. Freehouse that to be taken off the calendar, we must enter a notice of settlement. So I reach out to Judge Brasher again, because I want to make sure that the settlement is solid enough that we can announce to the court that we can enter a notice of settlement and the case is settled. I have a conversation with him on January 3rd, where he confirms, yes, the settlement is solid enough. You can enter that notice of settlement. At that point, I send a proposed notice of settlement to Mr. Russo and Mr. Mays. That email is sent with the term sheet at the bottom of it. It is part of the same email thread. So this is the second time that they are being sent the same term sheet, and they're being asked to approve the notice of settlement that reflects those terms. They do some edits. They ask me if I approve those edits. I approve those edits. And then they say, yes, you have our permission to sign and to file that notice of settlement. That happens.
Mr. Carter, forgive me for interrupting you, but so I did actually read everybody's briefing and I looked at everybody's attachments. And one of the reasons that I'm interrupting you is I agree with your assessment that you sent emails and term sheets that included this language about that it's tied to some sort of asset that we must be able to underwrite in some manner. I agree with you. And I understand your argument is I sent this over and over again and they never objected, they never objected, they never objected. But how do I reconcile that with the fact that their response is, but here's this email from Judge Brasher that says, that is not what I understood the parties to be agreeing to.
Sure. First, so I'll skip the part that I was going to get to, but what we have here is a confidential mediation. And Judge Brasher issued that email to us because that is his recollection of what happened. It's not subject to cross-examination. It is not sworn. and they are now trying to introduce it as evidence. If Judge Brasher was going to be put on the stand, he would say, I can't reveal anything about the confidential mediation. That's how confidential mediation works. But the questions to be asked to him would be, why did you approve this term sheet in my presence and watch me hit the send button on December 22nd? Notably, his email does not directly address the term sheet. It says what his recollection is 2 months later. It does not say Carter's wrong, Carter misled us all along, I've never seen or heard this at every time. He never actually addresses it.
Can't imagine Judge Brasher saying such a thing ever, but
He's an honorable person and he's a diplomatic person, so I agree with you on that. But the fact is, in no way does he even address the fact of the term sheet, which he has been sent twice, right? So what we have here is a recollection that they're offering, number one, should be excluded as any kind of evidence because it's not sworn, not subject to cross-examination. It's hearsay at the very best. It needs to be excluded. But number two, it doesn't actually directly address the issue, which is the terms were sent out and they gave permission to file a notice of settlement with the court on January 4th. And now 2 months later, they're coming and saying, we don't remember it that way, which is all Judge Brasher is saying. He's saying, I don't recollect that 2 months later. That is not sufficient to overcome the written record of what happened at the time. And they have actually not addressed that either. They've not addressed why they didn't object to the term sheet. They've not addressed any of that. What's really happened here is they didn't read their emails closely enough. That's it. And now,
Mr. Carter, let me ask you another question. So talk me through, so both parties are sort of taking this interesting position that we do have an agreement. Just you say it does include that term and the other side says it doesn't include that term. But one of their points, separate and apart from any recollection that anybody has, is that the language of the term sheet, as I have read it, Mr. Carter, is very vague, very general, right? It doesn't specifically identify a piece of property. It simply says something about being able to minimally underwrite. As I understand it, there seems to be some in the discussions amongst the parties indication that was Dr. Lapido's understanding that the asset she was referring to was this 5730 property. And I think all the evidence seems to be that Mr. Honan doesn't actually own that property. He owns shares or interest in the limited liability company that owns that property. So how would we, if the court were inclined to enforce a settlement, how do I reconcile this general phrase in the term sheet that it must be tied to an asset that can be reasonably underwritten with the real problem of the fact that Mr. Honan can't actually give you any sort of secured interest or underwriting in that building because he doesn't own it?
Sure. So I would start by saying that there would not be any settlement at all if there was not adequate security for the security agreement, for the promissory note. We would never have agreed to it. And I'm telling you right now, we did not agree to that. To the extent that they're now telling us that Mr. Honan does not own an interest directly in that building, that was news to us. So for the first time in their email in February, they say they don't have an interest in that building. But honestly, I think that's a bit of a red herring too, because the way the term sheet is structured, it simply says he has to put up a piece of property as security for the promissory note. Now, when I did the security deed, the only piece of property that I knew he had an interest in was the 5730 building. But that doesn't foreclose the possibility that they could have said, no, we're not going to put up that building. We're going to put up another piece of property. The intent was to get at something that Mr. Honan owns. And at this point, we don't know what he owns. But that doesn't negate the fact that they agreed to allow us to use some item of property as security for this. The other thing I'd point out to you is that if you look at Judge Brasher's email, he does not in any way address the minimal underwriting of Mr. Honan's personal guarantee. So we included that because if you go to a bank at any time and ask for a loan, the very bare minimum they're going to ask for is a personal financial statement. And they're going to ask for that 100% of the time. And that's all that we've asked them to give us. And that would be minimal underwriting of Mr. Honan's personal guarantee. They have not refuted that at all. And Mr. Brasher's email does not address that portion of it in any way, shape, or form. But the fact is, we negotiated for a piece of property to secure this promissory note. And that is what the agreement was. There is no settlement, and there is no grounds for enforcing a settlement without the property being attached to it, because the writing taken down concurrently with the mediation by me clearly indicates that my understanding was a piece of property would be used to secure that building.
Okay. So last question, Mr. Thompson, I think, at least for now. If Mr. Honan were to say, well, I own this other piece of property and I'll put it up as collateral, that would satisfy what you believed to be the terms of the agreement, correct?
That's correct.
And it would obviate the need for any sort of personal financial disclosure or other providing of financials to you. Is that right?
No, they're both required under the term sheet. Now, one of the arguments that they have brought up is that I do represent a group of plaintiffs pursuing essentially the same claims as Dr. Lapido in another matter. And they're trying to make the argument that because I represent this other group and that information will be subject to discovery in that other group, I cannot possibly have it as part of a settlement agreement. That doesn't jive. When you go to mediation, you can ask for and negotiate for literally anything that you want. And that is exactly what we did. And my ability to mediate this matter is not in any way constrained by any other case that I'm doing anywhere else in the world. That is a non-starter, but that is what they would have you believe. It just doesn't jive. But to answer your question directly, the term sheet that I put together clearly lists some sort of minimal underwriting of some sort of Mr. Honan's personal guarantee, and then as a separate item, a piece of property to secure the promissory note.
Okay. Anything else?
No, Your Honor, not this time.
Mr. Russo, I'll be hearing from you.
Yes, Your Honor.
Okay.
So, just to back up, we had the mediation on December 22nd, pursuant to the court's scheduling order. We had Judge Brasher as our mediator. Judge Brasher had both parties in separate breakout rooms, just like a typical mediation. Dr. Lapido was there virtually. Mr. Honan was there in person. The parties spent a significant amount of time throughout the day going back and forth on the payment amount and the structure of the payment plan. That was literally the bulk of the discussion, which is typical in any mediation and settlement agreement. At the end of the day, the parties, we believed, and we believe, had an agreement on the payment amount, the payment arrangement with an upfront amount, and monthly payments that would be made for 18 months, which is reflected in the term sheet, along with payment in full, and if there's a liquidity event that would allow our client to pay the remainder in full, in addition to confidentiality agreement, non-disparagement, so on and so forth, and a personal guarantee by Mr. Honan. And what is in the term sheet is identified as a secured promissory note. It states payment terms to be memorialized in a secured promissory note, personally guaranteed by Scott Honan. Now, we received the term sheet and we understood that to be the personal guarantee of Mr. Honan. Whenever we received the term sheet on December 22nd. Fast forward to early January, about January 4th. This is in the exhibits. We emailed Mr. Carter to inquire about the settlement agreement and the status of it. Mr. Carter responded that day and said he'd be sending us a settlement documents the following day. On January 19th, so several weeks later, I email Mr. Carter, ask about the status of the settlement documents, and remind him that, we notified the court that we'd be filing a dismissal by the end of January. So we needed to get the settlement agreement finalized. We didn't hear anything. Fast forward to January 30th. I email Mr. Carter again about the settlement agreement. No response. On February 2nd, my colleague, Mr. Mays, emails Mr. Carter once again. Now, this is after the deadline that we had to dismiss the lawsuit. And on February 3rd, Mr. Carter emails us and attaches the draft settlement and several other draft documents, which are included in Exhibit C to our response. And those included, not only the draft settlement agreement, but a promissory note, personal guarantee, and then a deed to secure debt, a vesting map, a property operating statement, and a personal financial statement form. So we emailed Mr. Carter since we finally got the documents, and said, well, this isn't what we agreed to. There was some back and forth over several weeks, and we suggested maybe the party should contact Judge Brasher since he was involved. We don't hear anything until until Mr. Freehoff contacts the parties on February 27th to say what is going on. At that point, we went ahead and emailed Judge Brasher ourselves, and he happened to be out of the country. He came back and said on March 8th, he sends us an email and about the security deed, and he states, quote, it was clear to me that such a means of, quote, securing in the vernacular the debt with a security interest in the property was never an option and was not part of the agreement of the parties. So Mr. Carter says that he confirmed with Judge Brasher what the term sheet said, and Judge Brasher then comes back and says, well, that's not what was discussed, and it wasn't what was discussed. Mr. Honan had no ability to secure this settlement payment by the property. Frankly, I don't know if he owns any property in his own name, and that was the whole purpose behind having a personal guarantee, was that if for some reason these entities don't pay up under the promissory note, then Mr. Honan's guaranteeing it. So there are ultimately two issues. One is the deed to secure debt. Two is these underwriting documents that Mr. Carter has referred to. And if we take a look at the underwriting documents and the settlement agreement, the settlement agreement is also attached as Exhibit C4 to our response. The settlement agreement lays out what this information is. It's not just a personal financial statement. It's a schedule of real estate owned by Mr. Honan, exhibiting direct and indirect interests and ownership interests in all properties. Total value of all of that real estate less existing debt. 2 years of federal income tax returns of Mr. Honan. Rent rolls for the property. That's a trailing 12-month calendar of rent rolls with specific information. Another 24-month trailing 24-month statement of income and expenses on a monthly basis, and a property operating statement, and then this vesting map, which according to the draft settlement is a map of entities subject to collateral. Again, none of these documents were discussed. None of this information, providing this information, our view is that underwriting the asset. Well, the settlement agreement's already going to have been entered when she would be getting this information anyway. So it doesn't seem to be material for starters. This financial information.
Well, let me stop you for. Sorry, Mr. Russo. So let me stop you and ask you a couple of questions. So I think it seems clear that everybody agreed there would be a personal guarantee by Mr. Honan as to the settlement figures. It also seems clear to me, in fairness to Mr. Carter, that he did circulate this term sheet and that no one specifically said, "What are you talking about?" That we didn't agree to that. But the language itself is fairly vague, and I'm referring to item 1 sub 3, which is the payment terms are to be memorialized in a secured promissory note personally guaranteed by Mr. Honan. Plaintiff must be able to reasonably underwrite the asset to which the secured promissory note attaches and the personal guarantee of Scott Honan. So to the extent, for a moment, for argument's sake, there was some agreement that there would be some minimal underwriting of Scott Honan's ability to satisfy on a personal guarantee and or to attach it to a piece of property, which is what that language seems to say. How would that be accomplished short of what Mr. Carter is requesting, if in fact that is a material term of the agreement?
I don't think that it could be accomplished, Your Honor, because there is no property to attach this to that our client has the authority to attach a security deed to. So there isn't anything, if that's what you're asking.
No, I guess what I mean is what I heard you saying just a moment ago before I asked the question was an objection to the particular nature of the information that had been requested from Mr. Honan as part of the settlement. And so my question is there some universe of information that Mr. Honan would be comfortable producing that would provide minimal underwriting of his ability to personally guarantee the settlement agreement?
I think that's something I would be more than happy to speak with Mr. Honan about. I don't know that his tax returns would be it, just given the nature of what is in a tax return. But I suspect that Mr. Honan would be willing to provide some information, some limited information to reasonably underwrite the note of his own. He does not have the ability to provide financials of other entities, especially entities that are not parties to the settlement agreement. So, in terms of his personal information, I'm sure we could come up with some data, some information that we could provide to show his finances. But to me, that's a precondition to the settlement, is providing that information, and I guess Dr. Lapido then deciding whether it's sufficient. And so I'm not quite sure that, again, it gets back to the materiality issue, and the parties had an agreement on the settlement. We then provide, I suppose, some documentation, and she comes back and says, well, no, that's not sufficient.
Yeah, and I mean, I think what I'm struggling with here is that it seems clear to me that the parties intended to settle the case, and that normally, right, how somebody pays a settlement isn't typically something that is important or comes up in a settlement, either because the person understandably has the ability to pay, or because, we're focused on the dollar amount, whatever. But what I'm struggling, and so in many circumstances similar to this, I would have no problem saying that the ability of the defendant to pay, other than this, I think, clear agreement to sign a personal guarantee, isn't necessarily a relevant or material term to a settlement. But the fact that it was reduced to writing in a term sheet in whatever sort of vague general language makes me concerned that that was something that was a significant factor. And that's what I'm trying to resolve, because I'm in this weird universe in which the plaintiff says there was a settlement agreement, the defendant says there was a settlement agreement, but they don't agree on what the terms of the settlement agreement were. And so that's sort of why I keep pushing back. I agree with the concerns that you're stating about that providing the information would be after the execution of the settlement in any event. And so maybe it's not material, but that's really what I'm struggling with, is that the fact that this is the issue that seems to be blowing it up makes it something that may appear to be more material in this context than it might otherwise be in a normal settlement dispute.
Well, and I think, the central issue would be the deed to secure debt. Mr. Carter can correct me if that's not his client's central issue. But I think that the evidence shows, or the record shows, that there was no agreement on a deed to secure debt, and I think it'd be unenforceable to begin with. So I think there's an issue there. In terms of the underwriting, our view is you have a personal guarantee, you have a settlement agreement, you can go enforce the settlement agreement. The underwriting documents, this financial information, again, it just gets back to not really being material or necessary. Whatever the financial records show, they would show of our client, and if our client didn't pay, the plaintiff would have a much cleaner case than the plaintiff has currently to go enforce that settlement agreement and that personal guarantee.
Okay. Anything else, Mr. Russo?
No, Your Honor.
Okay, Mr. Carter, it's your motion. So you get, well, it's actually both of y'all's motions. So let me actually, before I leave Mr. Russo, let me say this. To the extent that part of the defendant's position is that there was a settlement agreement reached at the mediation in December. Am I correct that as far as the defendant is concerned, the material terms of that settlement were the dollar amounts, the date and the schedule for those payments, and a personal guarantee by Mr. Honan, but nothing else? Is that an accurate statement of what you believed to be the terms of the settlement that was reached in December?
And a promissory note that the entities and Mr. Honan give to Dr. Lapido.
Okay, thank you.
It's just not a secured promissory note.
Okay.
Well, secured by real estate, secured by, we think, the personal guarantee.
Okay. Thank you, Mr. Carter. As I said, it's your motion essentially to start with, so you get the last word, but I would like you to specifically address for me that we are in agreement as to the dollar amounts. We are in agreement as to the schedule of those payments, right? The parties seem to agree on all of that. And that what the real issue is the extent to which there was an obligation to provide underwriting documents and or to secure Mr. Honan's promise to pay with a piece of real estate, whether it be the 5370 building or something else.
Okay. So the crux of our case is that Dr. Lapido was repeatedly misled by Mr. Honan concerning the nature of her investment, what the investment would actually be in, what Mr. Honan now apparently actually owns, et cetera, et cetera. We have zero trust in Mr. Honan. So frankly, selling for a personal guarantee was never an issue because it would make no sense for us to be accusing him of fraud and then accept a personally guaranteed promissory note secured by the guy who's been doing all the misstatements. That's our allegation, but that is what our mindset is on this. I would like to direct you to an inconsistency in what they're saying. No one questions that part of the payment structure involves a liquidation event, correct? 18 months from the date of execution final settlement agreement or the liquidity event. So we have this all tied to a liquidity event of a piece of property that we don't find out until after the fact is not owned by Mr. Honan, and we don't know what his level of control is, which means we don't actually know if Mr. Honan can make the payment from the liquidation event.
Well, hang on. Hey, forgive me for interrupting, but I mean, this is a piece of real estate. Real estate records are a public record. My understanding is that it was a piece of real estate where that anybody had the ability to go look and find out who owned it, and that all evidence seems to point to the fact that it was a special purpose corporate entity that owned this property, an LLC specifically created for the purpose of owning this property. So I'm not sure I'm persuaded by a sort of argument now that we believed Mr. Honan owned this property. Certainly, I understand that Dr. Lapido believed Mr. Honan had control over this property, but that's not the same as saying that he owned it.
I understand. All right, okay. I will retract that, but he was representing that he had sufficient control over that property to make a payment after a liquidation event. And now what we're hearing is that Mr. Honan does not have the ability to do that because he is in a dispute with the other partners in the building. So here is another reason why having a secured interest in some piece of property is so important. If Mr. Honan is telling us he does not own any piece of 5730, and he's now telling us he lacks sufficient control over that building to actually make sure that the liquidity event results in a payout, what are we talking about here? This is why we wanted the underwriting of the personal guarantee in the first place. And this is why security interest in something is necessary. It doesn't make any sense to do anything otherwise. And that is exactly what the term sheet says. And the very first thing Mr. Russo said, and we can go back and look at the record on this, we received it and we understood it. So they saw that and they read all that. To the extent they now disagree with the degree to which I'm asking for documents for a personal financial statement and real estate records and rent records and tax returns, I would tell you that those records are all exceedingly common in the commercial lending world. And if you're
right, but we're not in the commercial lending world, right?
Well,
we are in a, generally speaking, unless the parties agree to engage in further steps as part of a sort of quasi business contract, agreement to resolve a case. At the end of the day, this is a plain old settlement, right? Where I agree, I'm going to pay you some money and then you're going to dismiss your case. And normally the ability of one party to pay is not a material requirement of a settlement. Now, I agree with you that it appears to have been important to Dr. Lapido. But go ahead.
Your Honor, it could not be more material. We would not have agreed to any settlement without some way of underwriting this and securing it. That is a non-starter. And we said that at the very beginning. Well, and that's why the term sheet is structured the way it is.
And this is where I think that where the parties diverged is on the use of the phrase secured. Because I think when Dr. Lapido, it appears to me, was using the phrase secured, she meant tied to property. And there are other ways to secure a promissory note, i.e. by a personal guarantee.
The plain language of the term sheet, plaintiff must be able to reasonably underwrite the asset to which the secured promissory note attaches. It could not be more precise. There is an asset that secured promissory note must be connected with and attached to. And we need to be able to underwrite that piece of property. It's very clear.
Okay. So next question to both parties. If I determine that there was not a meeting of the minds and therefore there isn't a settlement, are we ready to go on the 24th?
Yes, Your Honor.
Yes, Your Honor.
Okay. I am going to, here's what I'm going to do. I'm going to take this under advisement. I'm going to issue a ruling today or tomorrow, so that y'all will have whatever knowledge or information that y'all need so that you can continue preparing for trial. If I determine that a settlement agreement did not exist because there was not a meeting of the minds on a material term, which was the extent to which the obligation to pay would be secured in some manner, which I think is what I understand to be ultimately the dispute and the proper legal framework for me to consider it, then the parties will proceed to trial on April the 24th, which is, hang on, let me look at my calendar. Yes, April the 24th is an actual jury day. So the parties would report at 9:30 on Monday, April the 24th for the trial of this matter. If in fact, by the end of the day tomorrow, I do rule that there is not a meeting of the minds on that material, on that element, if it is in fact material, then what I will do is schedule for next week a more fulsome actual pretrial conference for us to work through the pretrial issues. We will probably just email you and give you maybe a couple of dates that work for the court that have about 2 hours set aside to work through those issues. And then y'all can let me know which dates work best for y'all on that. Any questions, issues, anything else we need to address while y'all are here?
No, Your Honor.
No, Your Honor. Thank you.
Okay. Thank you very much. I believe, before I let you guys go, I believe that y'all both said y'all did send an email to Ms. Taylor so she can send you an invoice for the takedown. If you have not, then please do. If you have, thank you very much. Okay.
Yes, ma'am.
Thank you.
Thank you.
May we be excused?
Yes, you are excused.
Thank you.
Thank you.
Okay, so next up, that means we have Devon Jefferson versus Abdi Hudson and Marta. Okay. Ms. Taylor, are you ready or do you need a break before we get started? This is going to be a long one.
Are we ready, Judge? I'm sorry.
Yeah, that's what I was asking. If you're ready to go, we are, but this is going to be a fairly long one. So if you want to take a break, if I understand.
No, I'm good. Thank you, Judge.
Okay. Just raise your hand if you do need to take a break while we're going.
Okay, great. Thank you.
Okay, this is going to be a pretrial conference in the matter of Devon Jefferson versus Abdi Hassan and Marta, case number 2022 CV 362128. I will start by noting what I noted previously before we got started this morning when I was getting announcements, that this matter is set for trial on April the 24th. This matter today is set for a pretrial conference. And so I have the parties' proposed consolidated pretrial order. I have the parties' proposed motions in limine. I am also in possession of the defendant's motion for a continuance and a motion in response for sanctions associated with the alleged failure to preserve a video that would have been available like on the MARTA bus of the incident, which this is an automobile accident case involving a MARTA bus. Okay, so let me start with this. I have looked, Mr. Hawkins, at the motion for continuance as to your expert. I'm absolutely happy to accommodate the parties in terms of when we call that expert in, but the fact that an expert needs to be in Paulding County to testify doesn't limit his ability to, at some point during the week, also be in Fulton County to testify. And so I would not be inclined to grant your motion for continuance on that basis. But certainly we can take breaks, we can go out of order, we can take a whole day of a break if we need to so that you can still go in order with whatever presentation you're making, so as not to prejudice MARTA in terms of its ability to present that expert. But, you know, it's Paulding County. It is outside the perimeter, but it's not like it's, the moon. So, Mr.
Yes,
Hawkins.
yes. And again, just for clarity, and we'll talk about this issue that comes up in other aspects too. But one of the big kind of underlying issues that our expert got sick in the middle of all this. And so one of the things I'm sure we're going to talk about today is the fact that his expert depot still hasn't been taken. The day that he was scheduled to be taken, he said he got sick. And he had mentioned that there might be a conflict, but I couldn't get a hold of him because he was sick. And so when he got back, he told me, here's the subpoena that I'm under, here's the case I'm involved with. And he also told me that he has out of town plans pre-booked for that Friday. And so I guess he has to be in Florida on Friday. And so he was trying to leave Thursday. So he didn't say he wouldn't appear if he was under subpoena. I get the impression that he was strongly trying to attend that conference, that it was very important to him. So
again, I'm sympathetic to that, but I am also sympathetic to the fact that I used to be a lawyer in your position, Mr. Hawkins, and we pay experts tons and tons of money to be available when we need them to be available. And I suspect that ultimately your expert will find a way to make himself available, given that he has been paid, I'm sure, a lot of money by MARTA to do the important work that he does that we don't know how to do. So again, I will work with y'all in any way that I can, but I don't believe that is a legitimate basis to continue the trial from when it is otherwise set. So I'll start with that. Yep. The second issue I'll start with is the motion for sanctions. I've had a chance to look at it. I've had a chance, and I'll let you guys take a moment to make whatever record you would like to make in addition to your briefing. But I will tell you that literally one of the first cases I dealt with when I became a judge was a MARTA case that involved the spoliation of video evidence. And it was reversed by the Supreme Court, where the trial court had given a spoliation charge and or otherwise engaged in some sanctionary issue because the plaintiffs that were complaining about the spoliation had never in discovery made an effort to challenge the fact that wasn't available. And so I understand the appropriate standard to be that there has to be some initial preliminary discovery based effort to obtain that information or to secure for the record that it doesn't exist. And I'll accept this effort for sanctions to be that effort. But I will note that it is not the same. And if you look at that case, much of what the court was saying is that the purpose of the spoliation charge, the purpose of remedies associated with, hey, they had this evidence, they should have preserved it and they didn't. It's not supposed to be a gotcha. It's supposed to be, give me the evidence. I want the evidence. Why don't you have the evidence? And not necessarily just wait until the 11th hour and then say, well, you don't have the evidence, so I want this charge. So I say that only to give you sort of a framework of where my mind is about what the issues are associated with an alleged failure to preserve video evidence. I have read, as I said, your briefs. I am aware that to the plaintiff's mind, it's particularly relevant because MARTA has produced a non-associated eyewitness who alleges that the accident occurred in a certain way, that the plaintiffs believe the video evidence would have said something else or would be, important evidence on that issue. And so that's what I understand about the motion for sanctions. If you want to go forward, Mr. Who am I going to be hearing from on behalf of Mr. Jefferson?
Me, Your Honor, Drew.
Mr. Gilliland. So if you want to go forward and make whatever record you'd like to make regarding that motion.
Sure. So we requested the video multiple times in discovery, and it wasn't until I deposed the bus driver that I asked him how did the I basically asked him how the video system works, and he said that you can't start the bus unless the video system is working. He doesn't have any control over it. All he has is a green light, and if the green light is on, that means the camera's working. It was working that night, but for some reason, the video doesn't start until after the wreck, and there's no footage at all from any time in the day before that. But there is footage after the wreck happens, and and I won't beat a dead horse here because we already did the briefing, but the issue is, was our client speeding? Did Mr. Hassan, the bus driver for MARTA, have the right of way? The video would obviously help in that regard.
So just to educate me, in terms of the actual video that you're talking about, is it a video that shows the external area where the bus is driving and also a video that shows the inside of the bus, or is it just a video that shows the inside?
So it shows the inside and the outside. The footage that we do have that starts after the wreck, it shows footage on the outside and on the inside of the camera. You actually have a direct view of the bus driver from the footage. And so if he was distracted or on a phone or whatever, it would pick that up.
Okay.
And to add on to that, our expert testified that the collision itself would not have affected the MARTA cameras. And then he also talked about visibility. So we do think that the impact would have been visible from the footage.
Okay. Thank you, Mr. Gilliland. Mr. Hawkins?
Thank you.
Yes, Judge. So it will be our contention that, during discovery, this is the first time the sanction issue came up. So the questions were indeed asked during discovery about the green light. Our MARTA operator indicated the light was on and it was functioning. What this really was, and again, Your Honor, in our response brief that you recently received, is the idea that it was human error is what it was. MARTA did preserve. There is video that was preserved. There is a timing mechanism which they have to explain, hey, pull the video from this hour to this hour. And so what it was human error. The wrong hour got pulled. So video was pulled, video was produced. There was no intentional or bad faith or trying to hide or anything like that with regard to the video. And again, this issue was known by plaintiff in the first case back in 2021, and only on the eve of trial is the first time that we're hearing that there, is an issue about spoliation. And so, it's our position that, that one, there was no bad faith and no evidence that would warrant the type of charge or spoliation award, and two, that it was not brought up previously during the discovery period in this trial, either discovery period in case 1 or case 2.
Okay. So Mr. Gilliland, in reviewing the motion for sanctions, I believe that the request was strike their answer, or what was the nature of the sanction that you were seeking, or the spectrum of sanctions that are available to the court?
Yes, Your Honor. So we, as you correctly pointed out, striking the answer, The other one would be issue preclusion, essentially precluding them from saying that our client was testifying. So it would be striking a defense. And then the third option, in my opinion, would be an adverse jury instruction that you can presume that the footage would have been helpful to us had they preserved it.
Okay. And what I'm hearing Mr. Hawkins say, of course, obviously characterizing it is human error and, an oversight, unfortunate failure to comply with internal policy. Is there evidence in your record, Mr. Gilliland, that you would point me to, deposition testimony or otherwise, that you believe would imply some sort of bad faith failure to comply with their internal policy to preserve this evidence?
Yeah, so their internal policy preserves the video, or at least from their briefing, the video is preserved for 30 days. So if it was human error, first of all, human error doesn't, and anybody can say, oops, sorry, I made a mistake. If that was the standard, then there would be no sanctions whatsoever. But more importantly, the person who pulled the video did so and had 30 days to review it. The video would have been preserved for 30 days. So whoever pulled it, I don't understand why they didn't notice that they pulled the wrong video until it was too late to get the real footage, the good footage.
Okay, thank you, Mr. Gilliland. Mr. Hawkins, same question to you. I've reviewed your brief. I understand that your position is that there's no sanctionable conduct here at all, but that even if there is, that the appropriate way to deal with this would be simply to allow the plaintiffs to sort of develop those facts in the trial. Is that a fair characterization, Mr. Hawkins?
Yes, Your Honor, that's accurate.
Okay. Well, the reason I ask is I agree with you almost always. The answer is, so let me start with this. This is not a case based on what I've heard and what I've read in the briefs that would rise to the level of the striking of an answer or the striking of a defense. Almost always the remedy for this type of thing is to allow the parties to explain to the jury, to, bring in evidence about the fact that there should be a video of this, but there's not. The next question, though, is how do we, when it's time to charge the jury, how do we charge the jury on what they do with that? And I'm not sure, Mr. Hawkins, I'm not sure I understand Marta's position on that. Having read your brief, what is Marta's position on that issue?
Yeah, Your Honor, our position would be that a charge would be inappropriate, that he could bring, again, as you correctly identified, that plaintiff can bring it up at the trial. There, where is the video? Why isn't there a video? But I think to charge the jury on something would rise to that level of sanctioning Marta for conduct that ultimately was, like I said, not rising to the level of bad faith. Okay. Again, we had the video, we produced the video that we did have. It wasn't like we're trying to hide anything. It just was, it was the wrong time frame that got pulled.
Okay. Okay. So here's what I'm going to do. I'm going to deny the motion for sanctions to the extent that it requests me to strike the answer or to strike Marta's affirmative defenses or general defense that, that the plaintiff was speeding or, their general factual defenses about how this accident happened. And I think the remedy here is that the parties can go into as little or as much as they think is necessary, the reason that there should be a video and the reason why such a video doesn't exist, et cetera. And then at the time we have a charge conference, the court will decide based on the evidence I've heard, whether or not there is sufficient evidence that would justify, that would justify an adverse instruction to the jury about how they might consider the absence of that video evidence. So that's where we're going to leave that motion for sanctions. It is, I'm basically holding it under advisement until after the evidence is presented, but I am denying any request for a striking of the answer or a striking of defenses or limitation of Marta's defenses at this time.
Okay, thank you, Your Honor.
Okay, so I think that takes care of those matters other than the motion, the actual pretrial conference and the motions in limine. And so let me switch over to, I've got to pull it up on my computer. Let me switch over to your proposed pretrial order, and let's walk through that real briefly. First thing I'd like to do is give you guys an opportunity to sort of ask if you have questions about, I'm going to try and outline for you a little bit about the way I do things. And then to the extent you have questions about how that is going to happen, I'm happy to answer any of those questions. So this matter is set to begin on Monday, April the 24th. You obviously just heard me tell another set of lawyers that their trial is supposed to start on Monday, the 24th. I suspect that that case may resolve prior to trial, but in any event, we will be in touch with you, day to day, and let you know. But absent unforeseen circumstances, you should be preparing and planning to be present on the 24th to select a jury on that day.
And Your Honor, I'm so sorry to interrupt. I just wanted to ask, because my clients and their family and friends have to request work off because they're paid by the hour.
Yes.
I just want to be able to give them enough notice.
Yeah. And as I said, I will give you as much notice as we can in terms of, if the Lapido people are telling me we're going to trial, and it gets to be Thursday, Friday, then I'm going to tell you, yes, they're going to trial. But because I suspect that case may end up, it's already settled once, right? It fell apart, but it already settled once. And so I suspect that it may ultimately resolve again. And because of that, I would expect that because I suspect there's a possibility even that they show up on Monday and say, yeah, we resolved the case. And so that's why I'm telling you very strongly that you should plan and prepare for that Monday. And as soon as we have word that it will not be that Monday, we will let you know. I don't mean to take advantage. And of course, I'm happy to provide any documentation for anybody that has to be here, whether it's MARTA's employees or doctors or the plaintiffs themselves. I'm happy to yell at anybody that needs to be yelled at if they give them a hard time about being in court when they're required to.
Thank you, Your Honor.
Okay, so what will happen is typically we will give you 36 jurors. Does anybody have any reason to question or believe that we might need more than 36? Anything unique about this case that you think we might need more than 36 jurors to get a jury?
No, ma'am, not from the plaintiff.
No, Your Honor, not from the plaintiff.
Thank you, Mr. Hawkins. Do you want one alternate, two alternates, and do you want to agree that if we were to lose a juror that we would go forward still with 11 jurors? What say you on that issue?
I'm happy with one alternate and going forward if two get knocked. What do you think, Mr. Hawkins?
Yeah, that sounds good to me. One alternate.
Okay. So we will target 13 jurors, and we will note that we tentatively discussed that if by some crazy set of circumstances we were to lose 2 jurors, that we would still potentially proceed with just 11. Okay. Let me pull up. There we go. I have 2 screens, so I can look at this document and actually see all at the same time, and sometimes it doesn't work. The parties estimate 3 to 4 days for a trial. Does that include jury selection on Monday?
From the plaintiff, yes, that includes jury selection.
Yeah, if we include, I would lean more towards 4, but
okay.
Yes.
Okay. So, and the only reason I ask is that, in my little intro spiel to the jurors, I tell them, hey, look, we're going to need you here until X date, and always try to under promise and over deliver, right? Tell them they'll be here forever and then let them out in 3 days. They're happy as they can be. So what I would probably do if we're starting on Monday is tell them that we might need them as long as Friday. So that we can get any difficulties or burdens, travel issues that they might have. Any disputes in terms of the parties that need to be qualified for purposes of the jury in terms of MARTA entities, anything like that?
Not from the plaintiff, Your Honor.
No, Your Honor, not from the defendant.
Okay. I have not had a chance to look at your, I did see that I had some deposition designations that were submitted. I have not had a chance to look at the actual, I think you guys sent over some proposed exhibit lists. I haven't had a chance to look at them in detail. I will tell you that what I require the parties to do is to essentially, so I used to practice in federal court, so that's what I like to look at, is that table. One of the reasons I like that table is it helps me keep track of what documents have been offered, what's been admitted, what's been declined. It also serves, I have found, as a great resource for the parties at the end of the trial to make sure that all their exhibits got in, because I'll happily share it with you. I mention that because the other reason is I'm a firm believer that if there are 1,000 documents and 900 of them, everybody agrees are coming into evidence. Nobody's going to dispute the authenticity of them. They're appropriately certified. They're relevant to an issue. There's a basis to get around any hearsay objection. Then you would be shocked at the number of hours that can be saved in a trial by not having to say, I'm showing you a document that's been previously identified as Exhibit A. Do you recognize that document? Can you tell us what it is? Your Honor, I move to have that document admitted. Any objection? No objection. That sounds like it takes nothing, but that's a minute for every document you try to get into evidence. And so to the extent that the parties can dispense with that and just say, these documents are all admitted, except as to perhaps relevance as it comes in, right? So you can just say, this is a document that's previously been admitted as whatever, and let's just move on. And save our arguments for the actual documents where really a foundation needs to be laid through an appropriate witness and a demonstration of relevance needs to be made at trial. To the extent the parties are able to do that, I would really appreciate it. I have found that jurors really appreciate it. So take that for what you will. And to the extent, the only other thing I will say is, even if you can't do that, oftentimes I get exhibit lists that say, all medical records. No. By the time we go to trial, even if you don't agree that they're admissible, I need a list that is Exhibit 1, records of this provider, and preferably bait stamped, so that when you want to show, if it's 50 pages and you want to show the person one page in that document, we can navigate it. I'm probably preaching to the choir, and you guys already have all this stuff done in this way because, you know, I know you guys are capable counsel who do these kinds of cases all the time. But that is my preference, and it makes it so much easier. Next point about documents. Certainly, I fully expect that everybody's going to be using the evidence board that we have in the courtroom. So we use Zoom rooms now because apparently we'll never be able to get rid of Zoom now that it's a thing. And so basically what will happen is every day that you are trying the case, we will provide you with a Zoom link and you'll log into Zoom, and the courtroom computers will all be logged into Zoom. And to the extent that you wish to demonstrate a document, to publish a document to the jury, there's a big giant board in my courtroom, and you would share your screen to that board and it would show up on every screen in the courtroom. A couple things are important about that. Number one, if you want to familiarize yourself with the technology that's in my courtroom, just let us know. We'll throw open the courtroom and let you come in and familiarize yourself with it. Two, you need a paper copy of all of your documents. And the reason is that what I have learned is that it is doable, but I have not seen anyone do it in a practically presentable way where you only show me and the witness the document on a computer screen when there are 5 other computer screens in the courtroom that you have to exclude so the jury doesn't see it unless and until it's been admitted into evidence. And so I have found that old school plays best, which is just hand the witness a document to the extent you need to have them lay a foundation, and once it's admitted, then you can throw it up on the board. Second reason that paper documents are still very important is that the jury during deliberations has no way of viewing electronic evidence of any kind. They don't have any computers, anything. So if you want them to have your documents, your exhibits to review while they're deliberating, it's going to need to be on paper. To the extent it's something like a video that's on a flash drive, that would go back with the jury, but they have to request permission to come back out into the courtroom and have that media played for them in the courtroom. So just letting you know, the limitations of the ability of the jury to take back evidence and that sort of thing. In terms of jury selection, the way I do it is I ask basic general questions, general, basic, qualified as to the parties. And, you know, do you know me? Do you know these lawyers? Do you know the parties? Are you related to any of them? Do you have an interest in MARTA? You know, anything like that. And then I'm like, hey, lawyers, do your thing. The only thing I do, I think that is a little different. And so I'm just preparing you in advance. I request that you ask general questions first. Yes, no, card raise with a number, right? The jurors, does anybody here know anything about, does anybody here have a law degree? Raise your card, make a note. What I don't allow you to do in that context is then immediately follow up. Hey, juror 36, I see you raised your card. Why did you raise your card for that question? So what I ask you to do is take notes. The other side asks general questions. And then you have the opportunity, we'll put 12 of them in the box, and you have the opportunity to ask all 12 of those jurors any questions that you would like in terms of following up on the general questions and or specific questions that you believe are necessary to determine whether or not that juror is an appropriate juror. Also, I generally try really hard to let you guys try your case and ask your questions and seat your jury the way you want to. But two things. One, please listen to the jurors' answers, because I've had it happen more than once where a juror will be like, no, I haven't had any kids in the last 3 minutes since I was previously asked if I had any kids. So please listen to their answers and don't ask them repetitive questions. Sometimes it happens, it's fine. Second is, I know there's a lot at stake for all the parties in the case, and every lawyer in the world thinks that they're going to ask that perfect question and figure out if this juror is right or not. But at some point, we really are beating a dead horse, and there's just only so much that we can ask these jurors to find out if they are minimally legally qualified to consider your case, because that is the standard. And so just be prepared that at some point I may cut you off and say, hey, look, guys, this is overkill. You've asked everything I can think of and then some. Let's move on. So, okay. Any questions about any of those things in terms of selecting the jury and sort of the conduct of the trial before we get to any of this substance of your case?
One question, Your Honor. Is this just a 1 week trial? 1 week calendar?
No. So I have a rolling calendar. So if we don't reach you, I have trial weeks. Hang on, let me look at my calendar. I do not have a trial week the week of May the 1st, which is the week immediately following you, but I do have a trial week the week of May the 8th, 15th, and 22nd. So if, for example, Lapido comes back with a hard yes, we really are going, I would call you in, assuming that their case would take an entire week. I don't have a trial week that next week, but then I could call you in and would plan to call you in the week of May the 8th, which I believe I can tell you the actual jury selection date, the week of May, it would be on May the 8th, Monday, May the 8th.
Okay, thank you.
And Your Honor, just for the general questions, in your experience, how long do the attorneys typically get to ask general questions before the 12 jurors are seated in the box?
It's entirely up to you. It's more, you know, I do require that you send me your voir dire questions. I'm not typically going to say, you can't ask that, you can't ask that. What I'm relying on is the parties to say, hey, I have an objection to this question. What I'm hoping, though, when you send me your list of general questions is that it's not 400 questions.
No, it won't be.
And then that's really all I request is, you know, I'm going to give you a chance to get up and talk to the jurors and establish a rapport the way you want to. I just ask that it be reasonable. And, you know, ideally, can we pick a jury in the morning and do opening statements in the afternoon? That's always my goal. But if it gets to be 3 o'clock, I'm not going to make everybody start openings at 4 o'clock in the afternoon. So we would just bring them back fresh the next day.
Okay. Thank you.
Thank you. Anything else about that before we move on to the pre-trial?
No, ma'am, not from the plaintiff.
Okay.
No, Your Honor.
Okay.
One question, Your Honor,
yes,
regarding the rolling calendars. suppose that the first case goes forward and we would be second, is it a possibility that we could start in the middle of the week and roll over into the next week? Or do you not have any jurors available for that following week? Should the trial continue through the weekend?
So the Lapido case would take more than 3+ days to try. So if it goes, I'm not going to reach you that week.
Okay.
But if they go and settle, or if they go and, resolve, I do have jurors available to me on April the 26th.
Okay.
And if I were to pick a jury, I do have the ability to continue trying this case through the next week. It's just that I have scheduling conflicts with motions calendars and other things that are scheduled the first week of May. So basically, here's what could possibly happen. Either you go on Monday the 24th. If you don't go on Monday the 24th, the likely options are you would go on Wednesday the 26th, or you would go on Monday, May the 8th.
Thank you, Your Honor.
Okay. Anything else?
No.
Okay. So I wanted to look at the proposed pretrial one more time and make sure. Are there any deposition designations? I thought I saw some, but I wasn't sure.
Yes, Your Honor, there are. We haven't had a chance to confer on those yet internally. I think, Drew, let me know if I'm wrong, that we could probably work some of them out, if most of them out on our own. We just haven't had the opportunity, but if you guys feel differently, completely understood.
No, I think Mr. Hawkins is right. We've had a good relationship, so I don't see a problem with that.
Okay, excellent. I appreciate that. Only reason I mention it is that obviously, if it's a matter of impeachment of a witness who's testifying, that's a different issue. But the main reason I ask y'all to really look at it is if you're going to be presenting deposition testimony evidence, there's a charge that I need to have available to me and make sure to tell the jury we're doing that. And then the second thing is, to the extent that you would be either playing audio or video for them of the deposition or reading it to them. The main reason I mention it is that if you are playing video and there are parts of it that we need to resolve ahead of time, I have found that to be a somewhat clunky process unless y'all have the ability to actually edit out those parts so that it just plays for the jury. And the reason that becomes an issue is if it's a video or something else and the jury asks to see it again, it's important that we make sure that whatever the jury is seeing again is what they saw the first time and not something different. So anyway, just ask you to work that out. And the deposition testimony is a bad example because, of course, they wouldn't see that again. But if it was like a video or something, so.
And Your Honor, we'll have a trial tech specialist, and he'll be able to edit videos on the spot, just in case that's necessary.
Excellent. Okay, so now, yes, I'm sorry. Did someone have a question? Okay.
Yeah.
Thank you. Okay, so now I think we're ready to move on to the motions. The pretrial order that y'all have submitted appears to be in proper, appropriate order. And so we will, at the conclusion of the hearing this afternoon, this morning, we'll go ahead and get that on file for y'all. And I think we're ready to move on to the plaintiffs and defendants motions in limine. Let me start by saying this. At the conclusion of our motions in limine discussion, I'm going to ask someone to submit a proposed consolidated omnibus order on motions in limine. I think that the defendants actually have like the handy little granted, denied, whatever. But what I typically like is just one written order. The Court of Appeals has expressed a preference for it as well. That literally says, I've ruled on the motions in limine. This one is granted. This one is denied. So I am going to ask the parties to present that to me. And I like it to be in a consolidated one document. There's a reason I like it that way. The main reason being that, generally speaking, my rulings on motions in limine are going to be what's sauce for the goose is sauce for the gander. And so your motion may say the defendant can't do X, And if I agree with you, that's fine. But the ruling will say nobody can do X, right? Because if one party shouldn't do it, unless there's a really good reason that the other party gets to do it, generally speaking, nobody should do it. The second thing is, to the extent that I'm looking at an 30-page motion in limine, 81, if I count the exhibits from MARTA. I do want to point out that one of the things I ask is, if your motion is make them follow the law, judge, then that motion is always going to be granted. So let's not spend our time on motions in limine that are standard, and let's focus our attention on actual motions in limine that are uniquely associated with this case, or about which there are specific issues associated with this case. So with that caution, Mr. Gilliland, or one of your colleagues, it looks like, well, I take that back. I don't know that it matters, but on my docket, it says the defendants filed their motion first. So, Mr. Hawkins.
Okay. Ms. Fulks and I kind of jointly went over these, so it might, let me go through them. Okay. Ms. Fulks, you want to start with number 1?
Your Honor, so some of these, may be pretty clear, and I will say just up front that, like the exhibits, opposing counsel and our side, we have not had a chance to confer regarding these, so it's likely that we could agree to many of these if we just had the opportunity to talk about them, because we both have substantial number. But do you just want us to go through each one?
Well, that's typically what I would do. But in all honesty, if you want to, here's what I think might be helpful. What if we were to take about a 10-minute break? Y'all go through the motions in limine, identify the ones you think really need to have some discussion. Let's have that discussion. And then if the parties want to go through and submit a proposed order that agrees to many of them, and then if there are 4, 5, 10 that cannot be resolved and need to actually be resolved, we can either schedule a Zoom conference immediately prior to trial, or we can do it in the morning while we're waiting on our jurors to get arranged and deal with those specific ones. But I would like to sort of move forward as quickly as much as we can on what's been submitted. But to the extent that the parties can agree on any number of them, and y'all want to take, it's noon, if y'all want to take 15 minutes to see if you can talk through some of that, happy to ask you to do that if you think that would be helpful, Ms. Fulks.
I do. What about you, Mr. Gillen?
Yeah, we can do that. Do you want us to do it here on the Zoom call or do it off camera?
I think it would be helpful to do it on the Zoom call. And I think the easiest way to do it is Mr. Freehoff and Ms. Taylor and we're all going to get out of the Zoom call.
Okay.
And y'all confer. We will not be listening. And then I'll come back at 12:15. And you guys, and we can put you in a breakout room if you'd like to, but I feel like if we just leave, then that solves the problem. And I'll come back at 12:15 and we will see if there are some, the ones that y'all really believe need to be addressed, and we'll try to work through those. Okay. Thank you all. We're in recess until 12:15. So Mr. Freehoff and Ms. Taylor, if you will either log out or mute your machines so that you can't hear anything, and we will leave you guys to it.
Thank you, Your Honor.
As the host, I must remain, but I give you my word, I will turn the volume on my computer all the way down so that I can just see mouths moving. I won't be able to hear anything.
Okay. No worries. Thank you.
Thank you.
Okay. So I think that the ones that we probably will not agree on, and correct me if I'm wrong, but that the preventability analysis, I think we'll have to talk to the judge about. Dennis,
can you
what
give
else?
me the number if you have it in front of you?
Okay.
So Drew, I just sent you both of the motions limine, ours and theirs.
Thank you.
I think it is
27. Is it?
You guys got a couple more than us.
Yeah, was the preventability one.
Yeah, that's right.
What number, Cameron?
27.
Okay.
That's going to be a big one. And then for our part, the perceptions of speeding by lay witnesses, I think we're unlikely to have an agreement on that. So we'll have to take that up with the judge as well.
And I think our client's driving record.
Perceptions of speeding, that's defendant's number. Can you give me the number?
That would actually be our.
I'm sorry.
That would be our motion number. Hold on a second. Just gotta pull that up.
So just so I'm clear, are we switching back and forth? Or are we going through? So
Well, I think we're just identifying those ones that we certainly have to bring up with the judge.
Okay.
So it would be our number 1.
Oh yeah, yeah, sorry.
Okay. For us, there's one about causation, the doctor's ability to opine as to causation. I think that's number. I think it's number 2 or 3 for us. Let me check.
We had 17 here, testimony of or written statements by plaintiffs treating physicians regarding causation. That's 17 on yours.
Okay.
Personal opinions of counsel, I think we all can agree that we don't need to be injecting our personal opinions in this thing. That's 16.
So is that one we can agree and don't need to discuss? Is that what we're saying?
I would imagine so. Drew, you intend on?
Should we just go in order though? I guess I'm concerned about us hopping around.
Sure.
That's
fine. Yeah.
There is an order.
Yeah,
Look at ours in order and just kind of go.
Do you want to start with yours or ours or whatever?
Ours is a longer, so maybe I guess start with ours.
Okay, let's do that. Let me pull it up.
Should be the second email, Drew.
Just one moment. Let me create a separate document so I can mark them on.
So hold on one second.
And just so you know, I mean, I can agree to number 1, except the only thing I can think of that wouldn't really apply is just our client's scar. I mean, I think that's just common sense that that's a permanent injury. So I think they could say that, but otherwise I agree.
Okay.
Okay. Yeah, I agree with you about the scar, and I get you.
Okay.
Future meds. Again, not sure how much you guys are going to go into it versus future versus just what he had and what he treated for. Just wasn't sure how much of that was a part of your case, but
I don't think that's a part of our case at all, actually. Do you recall anyone saying that he's any testimony about future expenses?
There was testimony. The question may have been asked indirectly, but it was basically speculative, and that's what we're saying, that unless there's non-speculative testimony regarding future treatments or the like, that we would object to those. So there's some testimony where the doctor says, well, we just have to wait and see what develops, we don't know if it's going to heal. That would be speculative. We would object to that. I think at some point.
So just to clarify, so we're not claiming, in other words, we're not going to put in front of the jury, that the plaintiff will require X number of dollars for future medical care. So we're not doing that. Okay. I think what the doctor is saying there, that, no one really knows, I think that could be said, right? Because he's not.
Not according to the case law. If you look at the law that we've cited, it's pretty clear that no one really knows. That's speculative. I mean, if no one knows, the jury can't base an award for future damages, future medicals on no one really knows.
Okay.
Yeah, and I agree with that. I mean, but I think that testimony can be heard, but we're not asking for future medicals, if that makes sense. So like we're not.
Yeah, but to the extent that it puts that issue in front of the jury when there's no credible evidence of future medicals, it shouldn't be before the jury. There has to be some foundation laid that it's an issue.
Well, maybe I suggest that if we don't think we're going to come to an agreement on something, we might as well just keep moving, right?
Okay, so
I think it deserves a little discussion, just so. I mean, we can take it under advisement if you want a chance to review the case law, but I think it's pretty clear on that point. And that's why this particular motion is so lengthy, because we wanted to, put the case law before you.
Yeah, so
and I think I've even at some point quoted possibly the testimony or the pages that would apply. It may have been done in another motion, but we can table that, but that's our position.
Okay, that's fine. All right.
We appreciate that.
Yep. Okay, so number 3, medical bills and treatment unrelated to the subject incident. Maybe I don't understand what are there medical bills that are unrelated to his injuries in this case?
So sometimes it does happen where sometimes when we get records, we get them, say, for instance, a person has gone to Grady. And so when Grady sends the records, it may not just be for injuries that are relevant to this specific case. And we're just trying to say, to the extent that there's something outside of injuries that may just be couched with the records, or, for instance, in this case, I know your client has a history of headaches. And so we've gotten some information regarding those, and some of the treatment may be from, his previous treatment regarding the headache issue, but it wasn't related to this incident. And to the extent that that might happen, we just wanted to raise it, not saying that, that's up to us to figure out how we parse the records and to make sure we go through them thoroughly. But, we do have a grouping of records from a specific provider that may be outside of his general treatment, and it happens quite often.
Yeah, so I mean, we're not going to put any medical bills into evidence for treatment that isn't related to this crash. As far as testimony goes for treatment unrelated to this incident, I think that obviously he had headaches in the past, so I think that we would have to address that somehow. I mean,
that's fine.
Okay,
we could work that out.
Okay.
Yeah, regarding the headaches.
Yeah,
so we can agree to that.
Okay, yeah. So I figured that would probably be part of your defense.
Yes.
So.
Okay.
Yeah, I think we can both address that.
So 3 we're good on. Is that correct?
Didn't hear you, Cameron.
Oh, so with 3 we agree on. We're okay with 3.
Yes.
Okay. 4.
Yeah, that's and just to clarify for 3 though, since you all will be saying that he had headaches in the past, I mean, we could also say that yeah, he had headaches in the past. We don't disagree with that, right?
Certainly. Yes.
Okay. All right.
For sake of simplicity, I think 4 is largely covered in our conversation about number 1 with respect to the scar. It's that lay testimony about any alleged permanent injury. I think that lay testimony about the scar is pretty obvious and fair game.
I agree.
Okay.
As to the scar, yes.
Yeah.
So, obviously, with respect to anything that would require a medical opinion, I think that's fine, and we've sort of already agreed on that. But the scar would be fair game.
Okay.
So agree in part, I guess I'll put here. Qualified agreement.
Yes.
Okay.
So he could certainly speak to that, or it's obvious.
Right.
Yeah.
5 is kind of interesting because while Cameron, you said you previously provided that body cam by probably no fault of your own, we're just seeing that. So we just went through it. It's an hour and a half long, so I got to admit I haven't seen the entire thing, but there are a number of statements on there from police officers and investigators. The main statement that would probably apply to number 5 was that the DeKalb officer that was at the scene first said something about a conversation he had with Courtney Dillard. And specifically, and why it matters is I think the exact quote was, the witness said that the bus was halfway through through one lane only or something. It was half sticking out.
Yeah, I think he said the bus had completed his turn or mostly completed his turn, or I thought it applied to something about how much of the turn he had right.
And so, I mean, we would certainly want to use that at least for impeachment of Mr. Dillard. So, and not to mention also the Atlanta Police Department officer opined repeatedly that Marta was at fault. So, I mean, I don't know how we could really agree with this one.
Okay. So we can take up.
I mean, Drew, do you have anything else to add on that?
No.
So we'll take up 5 then. Okay.
6, evidence or reference to defendant's corporate ownership size or financial status. I don't anticipate that we would want to raise that, right, Drew?
Right.
Can we go back to 5 for a minute? Are you all planning on calling the officer to trial at this point? I mean, have you made I know he's on the pretrial order, but is that in motion where he'll be there?
We haven't sent a subpoena yet.
Okay.
I'm not really sure what he could offer, given that he has the body cam and we have the body cam footage. So he's probably just going to repeat what's in his police report. If we have a disagreement about the admissibility of the police report, then I will probably call him live.
Yeah, I think we do have a disagreement about it. So that's the point. I think. Yeah. What comes in, what comes in terms of the narrative and, what his assessment is, especially since he didn't witness the accident himself.
Okay.
One thing on that, just while I'm thinking of it, that I think is very important, was that the officer had certain perceptions of where the collision actually occurred at the scene based on his contemporaneous review of like the damage patterns and whatnot. And I think that's going to be critically important.
And where's that testimony coming from? Is that from
the body cam? At one point, he's like, "There's all the debris. I know that this collision happened in the left lane." Something to that effect. I'm paraphrasing.
Okay, and what number are we talking about now? Is this still 5?
I mean, I'm not sure that this. Yeah, I guess to a certain extent, because it does go to a theory from a police officer. I guess you call it a theory. I think it's more probably a perception. He saw debris in a certain. Actually, now that I'm thinking about it, his specific testimony was that there was some sort of material put down on the road, like maybe to clean up oil or something like that, like some sort of white powder or something. And he was observing where that white powder was, and then he was drawing a theory that that's where the collision had to have occurred. So I think it does probably apply to number 5.
Okay.
And 6 we agree on, and then 7. I agree. I guess we're not. I assume, does Marta have excess coverage over and above its self-insured retention?
I have to. Yeah, I think they do. I think it's like over some god awful.
$5 million.
I don't know the exact number. So yeah, yes, but I think they do.
Okay, so I know there is that Ford case that said like where the jury wasn't qualified for excess insurance and it was a new trial was granted. So I do think we're allowed to ask about, if there's an excess layer. I think we're allowed, because if anybody works for that insurance company on the jury panel, we should be, we should know that. But other than that, I don't see why we would talk about insurance at all.
Yeah, the only thing is that it kind of gets into some of our motions in limine with respect to any insinuation that this would like impact the service that Marta provides to the public or otherwise would injure taxpayers. I don't know to what extent you would even suggest that, but obviously it's ever present when you have a public entity like this involved. So we just don't want the jury to misinterpret that, the effect of the judgment.
Okay. Yeah, certainly. That's not part of our argumentation. So yeah.
Well, were you saying, Dennis, that to the extent that Drew says it may be proper or warranted to mention the access carrier, that would maybe cross over into what you're trying to avoid, or you're saying that because we're saying we don't think it's appropriate under any circumstances, so we wouldn't be raising it in terms of insurance.
Yeah, so I think we're talking about two different things. For juror qualification purposes, Drew's saying we got to make sure that nobody has an interest in that insurance company. I think that's a separate issue, but one that's important, right? But then as far as the case in chief, if the jury is misled as to how much of a financial impact this would have on MARTA, or if it would have some sort of service reduction issues to, public transportation.
We wouldn't be arguing that at all.
Okay.
Yeah.
Okay.
Good enough.
Yeah. So you wouldn't be opening the door to it, in other words.
Yeah. So I think we likely can agree to 7. We just need to check the case law, but we would just want it limited to that simple statement, qualification as to this insurance company, and no further, comment as to insurance.
Yeah, that's fine.
Yeah.
Eight, yeah, I think we both probably agree on 8. I don't think we're gonna have an issue on that. Right?
Let me see. 8, any evidence regarding settlement or offers or yeah, no, I agree with 8.
9, yes. But obviously, like with the caveat that there's a liability defense that has been raised, so that we think is refuted. So, I mean, we obviously will talk about that.
About the liability, right? Our liability arguments with each other. Is that what you're saying?
Yeah. Yes.
But that would go to settlement talks, right? Or failure to settle.
Not anything with respect to actually, we didn't get this thing done in mediation.
Okay. All right.
I mean, obviously our argument is there shouldn't be a liability defense here, but that's not this. So yeah, I think this is fine.
Okay.
Well, is that just because liability is in dispute and you're saying that, our theory is wrong as to liability, or are you trying to say that we should not have defended the case? Because those are two different things.
No, I think mainly, and this kind of gets to another preventability thing, is if MARTA believed it was preventable, and the officer believed it was MARTA's fault, then it ought not be in trial to begin with.
Okay, but just realize that, essentially we're going to be arguing that the police officer and the preventability, that's not the, the preventability finding, that's not the legal standard to determine negligence. So while those things may be true, that doesn't, get us out of determining negligence, pursuant to what the statute says.
So I'll make it simpler. We're not gonna say that you should be punished for not settling.
Yeah, we're not going to bring up settlement discussions at trial.
And 10 is a golden rule argument. I don't think there's anybody have any issue with that.
Themselves in the position of the plaintiff. Yeah, golden rule argument. Yeah, so in other words, I can't say to the jury, imagine how you would feel, or what would you want if? Yeah. No, I that would be a mistrial.
Okay.
11 is we can't ask the jury to send a message to the defendants.
Yeah, let's see, number 11. Defense counsel from asking jury to say, yeah, I'm not going to say send a message to MARTA. I think that would also, I don't want to mistry the case, so that's dangerous territory to me.
Yeah,
gotcha.
Good enough. 12. Mention of the fact that the defendant is not called to testify any witness equally available to both parties in this case.
What do you mean by equally available?
So for instance, trying to imply by saying, MARTA didn't cause such and such, if you could have called that person too, making an inference as though we're trying to hide something. Let's see what this is.
I guess
All right,
that's gonna-
counsel, judge is planning to reappear in about 15 seconds, so I just wanted to give you a warning.
We've made some
Okay.
progress.
we made good progress. We're not done yet, but
Okay, just let her know when she comes on.
okay.
Just before the judge comes, I think the only issue with that is, am I to understand nobody from MARTA is going to be there?
No, that's not correct. We're going to have the operator there as well as someone from claims.
Are you going to have Courtney Dillard present?
That's our intention.
Yeah, we plan to. Yeah, I haven't subpoenaed
Okay.
them yet.
Okay.
Well,
So,
present, and, like sitting at the table, like we plan to subpoena him to.
Right.
Yeah, okay, right.
yeah, so I guess the only people that like people from MARTA wouldn't be equally available to us. So if an issue comes up in trial, like with a video, we can.
Hello. If y'all
Hi.
like to continue talking offline, I welcome you to do so.
We will, Judge.
I think
and
We're making
I'm
good
certain-
progress.
Yeah, and I'm certain that you will. Have we identified some that that we need to spend some time with today, and others perhaps that y'all could just submit a proposed order?
Yes, Judge, we have identified some that we'll need to spend some time with today.
Okay, so Ms. Taylor, are you ready?
Okay, I am. Thank you.
So Ms. Fulks and or Mr. Hawkins, if you could identify for me in the defendant's motions in limine, which ones you think we should start with?
Let me confer real quick. I had 2, 5, 17, and 27. Is what I had written down. Just to.
I think we said we were going to table number 2. Take up with the court. I had number 5 regarding the body cam footage.
Yeah.
I think 17 and 20.
I will say, Your Honor, that the body cam footage, both sides are still trying to parse out the testimony that we would each find objectionable, if any. There likely will be portions of it that we want to enter into evidence, but
Hang on, Ms. Fulks, let me just clarify though, the actual number 5 says theories or opinions of police officers or investigators based on interviews of witnesses. So is it that those opinions and theories might be contained in the body cam footage?
yes.
I can help.
Possibly.
I can help a little bit. Your Honor, we recently reviewed the body cam. It's an hour and a half long, so we don't have a holistic understanding of it. But we did. There's one comment by the original officer that was on the scene. He was a DeKalb County officer. There was a jurisdictional dispute, and he said something to the effect of, "I talked to the witness, and the witness said that the bus was halfway in the street," or something along those lines. That's refuted by that witness in subsequent testimony, as well as the driver from MARTA, as well as the expert from MARTA. So that is probably the primary focus that we're going to be having to discuss, is that comment specifically, how that can be used fairly and what, if any, impact is there. I presume we would use it for impeachment.
Okay, so here's what I want more clearly. So the case law that I'm looking at that that MARTA has cited has to do with an affidavit of a police officer, and that we're way past that. So in understanding what ruling you're asking me for, how are you anticipating that this testimony would come in, that these problematic opinions? Is it that you anticipate one or more police officers will take the stand? Or is it that you want some party or other wants permission to show some or all of the body cam footage, and that the parties are generally in agreement that that footage would otherwise be relevant and admissible, except for potential issues associated with some of the things that are included in it? Is that a fair characterization of the issue?
So I think it may be twofold. So to the extent that plaintiff intends to call the officer to trial, if his opinions are based on information that he's received from witnesses on the scene, that's going to be an issue in terms of if he gives opinion testimony based on those witness interviews. And then there's the body cam issue. So it's twofold. And this also goes to the affidavit in the police report. There's also a narrative, and I'm not sure, just off the top of my head, I don't think that he says in the narrative, this is what the witness told me. In this case, I believe he doesn't even, the particular officer that's at issue that has authored the report, he doesn't even mention the witness.
Judge, a little context. Atlanta police never talked to the witness. As best we can tell, he was gone by the time Atlanta police got there because of that jurisdictional dispute. So the only person other than MARTA employees who talked to that witness was one DeKalb County officer who we can't identify specifically who it was. They actually generated not a single piece of paper from the police report police department that we can find. So we have one unnamed, unknown officer at the scene. When he's handing off the scene, says something to the effect of I talked to the witness, the bus was halfway in the intersection, something like that. And that is going to directly refute the witness's testimony, at least on 2 subsequent occasions. And so I would imagine, to your original question, how I think this will play out, assuming that this witness comes, the question will certainly be posed to him, what did you witness? Consistent with his under oath testimony, I imagine he will say the same thing he said under oath, that the bus was completely clear to that intersection. But that's directly refuted by what he apparently told the DeKalb County officer at the scene.
Okay, so I appreciate all this context, but we still haven't really gotten to what my question is, which is the defendants have filed a motion in limine that wants me to prohibit officers or investigators from stating theories or opinions they have about how the accident occurred based on statements they obtained from witnesses.
Well, so
what is the plaintiff's position on that?
So that goes to, I mean, that goes straight to one of the hearsay exceptions, that an officer investigating a crash or doing any kind of investigation, well, how do they investigate? They investigate through witnesses. So those would be admissible pursuant to the duty that a police officer has to report those things. That would be our position, and that is actually let me see here. I think it's 24-803, number 6, records of regularly conducted activity. So it actually says that, acts, events, conditions, opinions, or diagnoses, those would come in under that exception.
And I think we have another motion in limine that actually addresses the report. It would be number 25, exclusion of the Georgia motor vehicle crash reports. And this is really what we were talking about in terms of the narrative portion of it, not the facts of where the accident occurred and who the parties were, more so his narrative.
Okay. It does seem to me that both of these motions are sort of a piece. Mr. Gilliland, do you want to address both of them? I mean, it sounds to me like you sort of have, but let me back up for a minute. Ms. Folks, tell me, obviously, tell me what is generally in motor vehicle accidents. It has been my experience and that the police report in some form, the fact that it exists, that it was taken, documentation of the when and the where, et cetera, comes in, if for no other reason than for the police officer to refresh their recollection about the circumstances. And if the police officer refreshes their recollection by reviewing it, it can often be admissible. I agree with you. There are often limitations that are associated with narrative statements and or recitations potentially of witness testimony. Not that those wouldn't be admissible potentially, but that there's additional showing that needs to be made. As I understand your motion, Marta's motion, it is that the entire report not be admissible based on 4941. What, can you address that in a little bit more depth, Ms. Fulks?
Just one moment, let me get to it again. Just one moment, let me. So the case law says the specific case of that narrative portion of a police report is not admissible under the business records exception to the hearsay rule, nor is other evidence that requires the reporting office to make a conclusion or express an opinion. And this would be as to causation.
I don't disagree with that characterization of what the law says, but that would require a redaction of the crash report, not its exclusion.
So I think we would, we would be okay again with the report in terms of the details regarding where the crash happened, who the parties were, but to the extent that there's sufficient evidence through other witnesses, and we've even agreed and stipulated to some of those facts, we don't see in terms of the need for the police report, why it would come in when those facts can be established through other evidence, including stipulated facts in the pretrial order. So we would object to the narrative portion. And again, all those other facts, there's just, the information is basically evidence would be duplicative and just a waste of time.
Okay, well, I've not seen the police report, but I've read enough about y'all's case to understand that the fundamental dispute here is that the police officer seemed to form some opinion or understanding that it was the bus driver's fault, said something to that effect to the bus driver, but then didn't actually issue a citation. So, and that Marta's position is the police officer had no basis to make that opinion, make that decision.
Exactly. I'm sorry, Your Honor.
That's okay. The reason I say that's my understanding, though, is because it would seem then that the understanding that the police officer formed after speaking to people, assuming that's what he did at the scene, would be relevant to the case. The manner in which that testimony comes in, it is a different issue. If the officer testifies, then he can testify about what he developed. Generally speaking, though, and Mr. Gilliland, or Ms. Fulks, I'm sorry, I'll let you respond. But either side, the sections of a crash report that say things like contributing factors, that say things like failure to yield, that say things like that, those are conclusions that were drawn by the officer. And whether or not those recitations in the report need to be redacted out, and any narrative that says such a thing, that's a different conversation. That's the conversation I think we need to have, because that's not the same as saying that the officer can't come to testify and say, and rely on his report to say, I interviewed these witnesses and this is what they told me. And so I determined whatever it is he determined. And then y'all can cross-examine him about the fact that he didn't give anybody a citation or whatever, and that he didn't actually do any independent investigation, and all the ways that I've heard lots of police officers cross-examined multiple times. Is that's typically how this type of issue would be resolved. Is that something that the parties can live with in terms of, if I have to rule on it, it would generally be that the motor vehicle crash report may be admissible, but that narrative statements about causation and portions of the report that include things like that would need to be redacted. That would likely be the ruling that I would give, but that's not the same as a live person testifying. Mr. Gill?
I'm fine with that, Your Honor. And I apologize. I cited the wrong statute. It's 248-8038, public records and reports.
Right.
And yeah, subsection B says matters observed pursuant to a duty imposed by law, as to which matters there is a duty to report. And that would be.
Of course. And this is the conversation I frequently have with lawyers, and we always get so caught up in what's in the report that we forget that, hey, they can say, this is what I know. These are the facts about which I am aware, and how they became aware of those facts. And that's all fair game.
Okay.
So in terms of defendant's motion in limine 25 to exclude the motor vehicle crash report, my ruling is going to be that it is granted, and we're going to grant it in part, which is that the crash report itself, to the extent that it's otherwise relevant, admissible in terms of, you have a witness that might need to refer to it or whatever, it can come into evidence. But the parties agree to redact it, to exclude portions of the report that include theories or opinions about what happened in the case, and that would include sections of the report like contributing factors, etc.
Okay.
Moving backwards then, though, to the original part that started this conversation, which was motion in limine number 5. I'm still a little confused about that one. Hang on. I've gotten my pages out of order. There we go. Theories or opinions of police officers or investigators based on interviews of witnesses. So generally, the line that would be drawn is a police officer can testify and say, I went to the scene, I observed the following things, and I interviewed people who I believed had knowledge, and this is what they told me.
I think this is talking about when he actually bases his opinions off of what they told him.
Right, but my point is that assumes that the officer would be able to give his opinion about how the accident occurred or why it occurred, as opposed to this is what the witness told me. That's what I'm trying to get to, because if the officer can testify about what he saw and what was told to him as part of his obligations, then my question to you is it plaintiff's intention to have the officer say, and so I believed based on what I heard that it was the fault of the bus driver?
So we have experts, dueling experts for that. Obviously I would like the police officer to say that, but if you don't want me to go there, I won't. So I think the police officer could say, I investigated the scene, this is what I did, and this is why I determined that the bus driver failed to yield. I don't think he could say that the bus driver is at fault for the wreck or is liable for the wreck, but I do think he can say these are the facts that led me to conclude that he failed to yield a misjudged clearance. But
I tend to agree. Ms. Fulks, we can go into this in some more detail as we get there, but based on what y'all are telling me now, the limited nature of what they're asking the police officer, what they anticipate they would be asking the police officer to testify about, would all be fair game and subject to the cross-examination of the fact that he didn't do any independent investigation other than talking to some people, right? He didn't measure anything. He didn't, whatever. I assume that's what I'm going to hear.
Exactly, Your Honor. He didn't really do an investigation.
Yeah, and that's
clear
often
from
what
the body
happens
cam.
unless it's a fatality and you got GSP showing up with some actual expertise. So to me, the theories or opinions of the police officer, which is item number 5,
and it's just, it's not just in general his theories or opinions, it's just based on interviews of the witnesses. If he says, this is what somebody else, this is what the other witness told me, where in this case, he didn't even speak to the witness and didn't speak to the plaintiff at the scene. He only spoke to the bus operator.
Right, but he can testify about what he did and what he was told. And if he formed an understanding based on those what he did, then he can say that. And then you can cross-examine him about how that was not a sufficient investigation and he wasn't justified in forming that decision. But I don't know that the simple fact that an officer's opinion about a failure to yield or an understanding of how the accident occurred is somehow improperly based on what witnesses told them. It might be an incomplete opinion, but I don't think it's an improper opinion. And therefore, I'm going to deny that motion. That's motion in limine number 5.
Your Honor.
Except, of course, that I do want to be clear that, as I said a moment ago when I was referring to motion 25, that is not the same as an officer, as somebody attempting to elicit an officer saying, and that's why I believe this person was at fault or caused the accident or something. That's an entirely different issue.
Okay.
And so as to motion in limine number 25, that was granted in part because of the redaction, and motion in limine number 5 is denied. Anything, what else do we have to take up?
I think we got to number 12 in their motions in limine. Like I said, I mean, there's quite a few. We made really good progress, but that's where we, I don't know, Mr. Hawkins, Miss Falks, I don't know how you all want to handle. Should we keep going through the motions and then?
One thing, Judge, so that we're respecting your time, I know that the preventability issue number, I think 16 or 17, I don't recall specifically. I know that's going to be an issue that we're going to need your guidance on.
Yeah, I mean, I'm just looking, I think one of the reasons that you probably made good progress on 1 through 12 is I'm looking at them and like one of them is the golden rule, right? Like, come on, guys. Okay. Personal opinions of counsel, things like that. These are all I put them firmly under the please make them follow the law, and we will follow the law.
Gladly.
Okay. 17, testimony or written statements by plaintiffs treating physicians regarding causation. Okay, so Ms. Folks or Mr. Hawkins, tell me specifically what you are concerned about. Is there a specific provider or a group of providers that you are concerned about a report that is going to come into evidence or be offered, or that they're going to testify about something? Tell me what that is.
So, Your Honor, regarding this one, there is testimony, and we find that this usually occurs in mostly every personal injury case that we handle, where as a matter of course, the treating physician during treatment, basically is on autopilot. And at some point in the record, they always say, it's my opinion within, a degree of medical certainty or something to that extent that the accident, that the injuries that he's treating for were caused by the MARTA accident or the MARTA bus accident. And they're specifically, I can't point to statements in the actual medical records, although I'm sure they're there. But there is testimony in the doctor's deposition where opposing counsel specifically asked him, is it your opinion that plaintiff's injuries were caused by the MARTA bus accident? And he says yes. And our position is basically that, especially in this type of accident, and this is basically a run-of-the-mill motor vehicle accident where the plaintiff has injured his head and the plaintiff has injured his back and neck, that in such a case, it's improper for the doctor to be able to do so. We have cited relevant case law. Our position is that the doctor doing so improperly bolsters the plaintiff's credibility, and that the decision of causation is one that should be left to the jury, that the jury is well qualified to basically draw the appropriate inferences that they need. In this instance, the plaintiff's injuries occurred right after the accident. You can even see the injuries, some of his injuries on the actual pictures. And so because there's not a gap between the accident and the actual injuries that occurred, and that the injuries are such that most people have a general, layman's understanding of this is the type of injury that could occur from a motor vehicle accident. Our position is that it's inappropriate for the doctor in this instance to opine as to causation in this case. And that in this case, the medical injuries are not such that the doctor's causal link or his opining to the causal link is even necessary based on the type of injuries that are at issue, and that him doing so unfairly bolsters the testimony of plaintiff.
So I understand your position. I think one thing that I'm concerned about is or not concerned, but that I question is it.
And
Usually,
especially, there's not a proper foundation here. There's not, if you look at, what the doctor actually did, the history that he took of the patient, that sort of thing. He doesn't even
all of
have,
which is great fodder for cross-examination as to why that is an uninformed opinion. But I think the issue I'm struggling with is the case law that you're relying on, I think, is more in the context of the case wasn't sunk because they didn't have expert testimony on this causation issue. And usually that's what I'm getting, is that they have to have causation testimony, and they didn't have any causation testimony. So they've failed to demonstrate the causation element of their claim. Usually doctors testify that it was my opinion to a reasonable degree of medical certainty that these injuries were a result of this accident. And then you're like, yeah, but what was that really based on? You were just basing that on what your patient told you and whatever. You didn't do any independent research. I'm just not sure I understand how this rises above the level of cross-examination such that I should prohibit the doctor from testifying.
Basically the position is that the testimony would unfairly basically cross over into the province of the jury. That is the jury that needs to decide based on the facts and the evidence that's presented to them, whether or not, who caused the accident. And for Dr. Barber or any other treating physician to be able to say that is improper and it's overly prejudicial because he's a doctor on the stand.
Oh, hang on. Let me interrupt you, Ms. Folks. You just said something about who caused the accident. I would never expect a medical expert to take the stand and talk about how this accident occurred or who caused it. But doctors are in the business of determining if an injury resulted from a particular type of trauma. And so that's well within the universe subject to cross-examination of what they're allowed to say. And then, of course, the jury can say, I guess here's what I'm struggling with, y'all. Usually when we're arguing about causation, it's because nobody disputes how the accident happened and that one party was at fault and not the other, but there's a dispute about the nature and extent of the injuries. But that doesn't seem to be what we have here. We dispute that this accident was the fault of the defendant. The defendant says it was the fault of the plaintiff. But the guy got his head cracked pretty hard. And then beyond that, my understanding from what I know about your case so far is there was visible injury to the person's head that required medical treatment. And then things beyond that might be, soft tissue, neck and back resulting from things like that. That's what I'm not following, Ms. Folks.
And that's true. There really is no, of course, plaintiff will have to prove their injuries, and they'll have to, produce certified medical records and the like and do all of that. There really, in this case, is not really any dispute as to what the injuries were. And we think it's pretty clear based on, the pictures, the testimony, and also the types of injuries that occurred, that in this case, because it is so clear and we're not disputing, the jury does not need the extra testimony of the doctor to opine that the injuries were caused by the accident. They can make that determination themselves based on the evidence presented. And we just feel like the law that we've cited says that doing so in this type of accident, where really treating doctor testimony as to, the cause of the injuries is not really necessary. Like we don't believe that we wouldn't say that if the plaintiff did not present this evidence, they have not proven their case. We believe this is
and Ms. Folks, I agree with you to the extent that we are talking about the immediately observable injuries that people don't seem to dispute about, the head trauma or whatever. But there's always an issue associated with subsequent treatment and soft tissue, whatever. Is that not an issue in this case? Is there not some sort of TBI, concussion, soft tissue, whatever? Are those issues in this case?
Yes, ma'am.
Okay. If those are issues in the case, then it is unfair for the defendant to take the position that they don't need expert testimony, because then you could turn around if they don't give expert testimony on that issue and say, well, they didn't demonstrate that any of that was causally related to this incident. You can cross-examine the doctors about whether their opinions are informed, but I don't think that there's a basis for the court to completely exclude medical testimony, given that causation, typically through an expert, is a minimal requirement, medical causation in particular. And so item number 17 is motion limiting number 17 from the defendant is going to be denied.
Thank you, Your Honor.
Anything else?
27, Judge. The preventability analysis.
Your Honor, on this one, there was a separate brief. It was one of the exhibits.
I'm sorry. And that was one of the separate exhibits that you gave me?
Yeah.
That was the one that was filed this morning, Your Honor.
Exhibit D, Judge.
Oh, I'm sorry.
Nanya, are you on mute? I can't hear you.
No. Can you hear me now?
Yes.
Yeah, I don't think Exhibit D was originally with the motions in limine. I think they're saying that they may file that this morning.
No, we filed that with the motions in limine.
Oh, really? It goes from, at least on mine.
Yeah, I don't have a D.
Yeah.
You don't have a D. Okay.
No, I'm looking at a printed copy of the defendant's motions in limine, and it goes from Exhibit C to Exhibit E. Okay, so I am, as I mentioned when we first got started, I am somewhat familiar with MARTA's operations. I mean, because they have exclusive jurisdiction in Fulton County, we end up litigating a number of these cases. I am generally familiar with MARTA's internal workings and the fact that they typically do post-accident investigations on their own to determine whether, as do most places nowadays that have drivers, to decide whether something was preventable or that the driver needs to be retrained or, disciplined in some way, whatever. So I assume, based on this motion, that MARTA did such an investigation and determined that the accident was preventable in some manner, and that MARTA is seeking to exclude testimony on that issue and the admission of some sort of document that was produced in discovery that says the accident was preventable. Is that a fair characterization of MARTA's position?
Yes.
Okay. Thank you. And is it Ms. Roy?
Ms. Roy. Yes.
Okay. Thank you, Ms. Roy. And just so you know, I don't have anything in this file after yesterday in terms of on my docket. So if you sent it to my staff, it may be that it's in my email and I haven't seen it yet. But if there's any separate briefing on that issue, I don't have it. And I am looking at your motion limine, and there is no D attached. So Ms. Roy, tell me, what is the concern? What is the concern just the document, or is the concern witness testimony of a MARTA witness about that issue? Both, and what is the basis for seeking to exclude it?
So it's both. We'd like to exclude the document that MARTA makes after following an accident, and we'd like to exclude any inference from opposing counsel that MARTA deemed the accident preventable. And our basis for that is threefold. It's that it confuses the standard of care because MARTA has a higher standard of care when it comes to determining the preventability of the accident. And so they actually followed the transportation safety guidelines to determine the standards of care. And it says in that manual that we attached as an exhibit that the preventability does not mean fault or does not assign fault. And then our second reason is that the preventability form that MARTA fills out following an accident is akin to a traffic citation, which is not admissible in civil trials. And then the third reason is that it's a subsequent remedial measure. So MARTA does these post-accident reviews to determine if their employee needs to be disciplined because they hold their employee to a higher standard of care, and which is higher than the normal standard of care in this case. Just so that for future, in the future that they don't encounter the same thing with their driver. It's not for purpose of establishing liability or fault. So those are our three reasons.
Okay, thank you, Ms. Roy. Mr. Gilliland, or?
Yes, ma'am. So there is there's a couple of issues with this. So both the eyewitness and the bus driver said the accident was the bus driver could not have done anything to prevent this accident from happening. So that's really key, because if we don't, the preventability analysis totally refutes the bus driver. And I don't even know why he testified saying that, because he already knew that MARTA found the accident to be preventable. So if they're going to offer testimony that the bus driver did nothing wrong and there's nothing he could have done to prevent this accident, then the preventability analysis has to come in, otherwise we're prejudiced. The other thing I want to mention is that we agree the preventability analysis is not the standard for negligence. It is a violation of a company's internal policies, which is evidence of negligence. And that's very clear in the case law. A violation of company policies is considered evidence of negligence, but it's not negligence per se. Now, if they want to agree that they will not have the witnesses or the bus driver say that this accident, that the bus driver did nothing wrong, then we agree the preventability analysis probably doesn't come in.
Well, I think there's a distinction, though, between the two things that you just said.
Okay.
Having the bus driver say, I didn't do anything wrong, is different than if the bus driver were to say, there's nothing I could have done differently. And so we have to figure out if that hair can be split or not, because the logical next question, if he's being cross-examined, is, so you didn't do anything wrong. Well, what could you have done differently? So we need to figure that out.
Judge, if I could just read one quick sentence from the deposition of the witness. The question was posed, from what you witnessed, is there anything that the MARTA bus driver could have done differently to prevent this accident? And his response was not at all.
So, but that's not a MARTA witness, right? That's just a witness.
A bystander. Yes.
Correct.
Okay. Well, but that witness wouldn't have any knowledge of what MARTA's internal policies and procedures are. So that witness's testimony, I don't think implicates MARTA's probability analysis, but a driver or another MARTA witness who presumably would have such knowledge might have that testimony by one of them might implicate the foreseeability or preventability analysis. But I don't think that an independent witness who's not associated with MARTA and would not have any reason to know what a bus driver is supposed to do or not supposed to do under MARTA's rules.
Except the witness said he's a professional driver.
That he has driven in the past as a professional driver, but he wasn't making his opinion as an expert.
No, he said he was a professional driver. He said, in my opinion, as a professional driver, and then he gave the opinion. I'm sure Dennis can find the exact language. I only have one screen though, so I can't.
Okay. So
Your Honor, can I chime in for just one moment? Well, in terms of the witness,
hang on, before you do, Ms. Folks, let me just tell you all that this is fine for now because we're just having a conversation, but at trial, there will be none of this, right? If it's Ms. Roy's issue, then Ms. Roy is the one who talks and Mr. Gilliland is the one who talks. And we're not going to have this, everybody gang up on everybody. Right now, we're just having a conversation, so it's fine. But just so you know, I don't like that at trial and we won't be doing that. Go ahead, Ms. Folks.
Your Honor, I just wanted to mention that, and correct me if I'm wrong, Drew, that the plaintiff has indicated that at trial, they plan to argue that basically, and this goes back to one of our other motions in limine, that basically Marta is giving contradictory defenses, that on one sense, Marta found that he was at fault, but then we are disputing liability. And so he's using it to say that basically almost like Marta is double-minded and we don't know what position we want to take. And we believe that the two are mutually exclusive, that the two standards don't even discuss the same thing. What Marta does internally is different than the legal standard for whether or not Mr. Hassan is liable. And to the extent that that's going to create confusion for the jury, to the extent that that information comes in, we will want some type of limited instruction because we feel like it's confusing.
Okay.
And it may be overly prejudicial.
So what I'm hearing from all of you, and this is the part, I don't think I can give you a ruling on this one right now. And here's why. I still don't have a clear understanding of how it is that the parties believe this would come into evidence. If there is a document, or if it's a line of questioning that would be asked of some witness or other. And that's the part I'm still not clear on. I guess the answer is in Exhibit D.
Can you guys look at page 47? Because in my file stamp copy of the motion, it shows up on page 47.
Okay. Hang on. What? Yeah,
that is in mine on page 47, but Judge, you may have a hard time finding that because it's only 47 by all of the documents in front of you, all 81 pages in front of you. Not
well, hang on. Let me see if I can find it electronically then. Let me see if I can pull it up that way. Okay, so yes, now I find on page 47 of the PDF a whole entire other brief in support of the motion in limine. Okay, that's helpful. Now I'm somewhat better able to navigate it.
And if you want, Judge, because these are filed late, I mean, we can brief the issue if you want.
Yeah, I feel like, so the plaintiff has submitted a full, Marta has submitted a full brief on the issue, and I think it would be helpful. It looks like it runs to multiple pages. I think I'm at page 10 and they're still going. Yeah. So I think it would be helpful to, for you guys to give me a written response.
Okay.
And we will take it up from there. In terms of, we'll take it up after you have an opportunity to brief. Let me look at my calendar. Would it be reasonable for you to provide me with that by the 19th of April, which is next Wednesday?
Yes, ma'am.
Yeah, we can do that, Judge.
Okay.
And Judge, while I'm looking at this, the excerpt from the deposition I was looking for was a question by Mr. Hawkins to the driver. Is there anything you could have done differently to prevent this accident from happening? Nothing.
Right. No, I understand that. My point was that if Marta does not take that position and the driver does not testify to that at the trial, my point was simply that the fact that a witness said that doesn't, to me, open that door. That the driver said it gets much closer to opening that door, but it also, I think, is dependent upon how that testimony is elicited and developed at the trial. And that's what I'm trying to figure out. Okay, so now that I have some briefing, I do still want to make sure I understand, though. I am going to wait until April the 19th to get additional briefing on Marta's motion in limine number 27. Do want to still make clear, and I'm sure I'll understand it better when I read your brief, but is it a document that somebody's planning to offer into evidence and or question MARTA's witnesses about? Am I understanding that?
Yes, it's a document. It's a MARTA's grading form for a post-accident. And also, we just don't want it even brought up.
Okay.
That MARTA deemed the accident preventable.
Okay, I understand. Okay, so we're gonna reserve that one for now, 27, until I get some additional briefing from the plaintiffs. Okay, anything else on the defendants?
Yeah, I think those are the big ones. I think most of the other ones we could surely come to some agreement about. I think we hit the ones that were, in dispute or would likely be in dispute or hotly contested.
Okay, I did want to note a couple of things that I saw. Y'all had something about approaching the bench. Just to give you an idea of how I typically tend to do things. So sending the jury out of the room every time we have a conversation that we need to have is just not practical. It takes forever. So generally what my practice is I think what the standard is, which is, look, if you can stand up and say, Your Honor, I object, may we approach, or Your Honor, I object, that's hearsay. And then the other side can respond or fix it without the need to approach, then let's do that. But if you have to say more than 3 words to tell me what your concern is, then those 3 words need to be, may we approach, and we will approach and we will have a conversation. And what will happen is either I will give you a ruling, send you back and have you conduct yourselves accordingly, or I will say, this is going to be more involved. We need to send the jury out so it can be taken down. What I typically do, if somebody objects, you come up to the bench and I give you a ruling, is I make a note of it. And on a break, I will then say, there was a bench conference held during this time about this objection. This is what the party said. This is how I ruled. And y'all can make any further record of that you want to make to make sure that your record is perfected. Generally speaking, the only thing I will say is if you say, Your Honor, I object, can we approach? You come up, y'all can step back. Counsel, your objection is sustained. Go ahead. Counsel, your objection is overruled. Go ahead. That's typically how I do it. And then the substance of whatever was communicated at the bench trial, so that we can make a record of it, I'll typically make a note. And then, and that way you can add anything you want to add in terms of what your arguments were. If it's anything that's more involved than that, then as I said, you just need to tell me, think we need to make a record of this, and I'll ask the jury to leave the room and we will have a more fulsome conversation, just so you know. Anything else on the plaintiffs? I'm sorry, on the defendants. Okay. So moving on to the plaintiffs' omnibus motions. Did we have any that we feel like we could dispense with, or that we believe we need to spend some time with?
Judge, on most of these, I think probably reasonable minds will prevail if we just spend a little time talking about it. The only one that I think might require some of your advice on is number 1, which is statements related to the contention that our client was quote unquote speeding. So 2 different witnesses, the driver and one witness, said that they believed our client was speeding prior to the collision. I think the easier one is probably the driver, because the driver has testified repeatedly that he never even saw our client. So I don't know how he would draw that inference. But the witness is a little trickier, in part because he holds himself out to be a professional driver, but also in part because he says in his capacity of professional driver sitting at a standstill, there would be no way for him to actually know how fast the guy was going, but he knows he was going over the speed limit. I think that the perceptions of the client, or of our client, that he was, for example, I think one of the points of testimony was that he heard his engine rev. I think that's a fair observation, and anybody could testify to that. But to draw the conclusion that as a result of that, he had to have been going over the speed limit, for example, would require some sort of specialized expertise that this guy just doesn't have.
Okay. Ms. Folks or whomever, if you'll start with the driver. I think, how do you pronounce your name, Mr.? Is it
Sawan?
Sawan? Okay. To Mr. Sawan's point, start with the driver. How would the driver have any basis to testify factually that Mr. Jefferson was speeding?
Right, Your Honor. So he was the one who observed. His testimony is going to be that when he looked out, he did not see the plaintiff's car at all. And so he was surmising that the only way that that car could have cleared that level of distance from having no car there to being hit at the back of the bus was that he had to be going at a rapid rate of speed. So admittedly, he didn't see him, but it's based on his lay witness or eyewitness, testimony as to what he saw and what he observed. And if plaintiffs want to cross him, question him on, whether that's credible or not, I think that'd be appropriate for them to ask that. But this is based on his observations, what he observed as the driver when he didn't see anything and then still resulted in an impact and a collision.
Okay. And then what about the witness?
Oh, well, the witness, I think that's much clearer. He saw it. He was watching the entire thing. He had a front row view of the entire thing. And so the witness can opine, as to what he saw, I think they even asked on cross, like, well, how would you calculate that? How would you know that? And so again, questions that would be, that plaintiff can ask him on the stand, but he physically was sitting there observing and saw the car moving. So I think that he would be able to speak to what he saw as a firsthand observer, as eyewitness testimony.
Okay. Mr. Sawan, anything to add to your motion?
Well, the witness did also get the speed limit wrong. I think that probably goes more to weight than whether he can opine as to how fast somebody would have to go to close a particular distance. But I'll just leave it at, I think it requires specialized knowledge to know that calculation.
Okay. So a witness testifying that based on the factual information they have, they believe they were justified in their own personal experience from determining or drawing a conclusion that a car was traveling at a high rate of speed is a fair area of testimony for the driver and for the witness. Saying that that driver was speeding is a legal conclusion that neither of them would be inclined to draw because, for example, Mr. Swan pointed out the witness said he didn't know what the speed limit was, but a high rate of speed or a perception by the driver or the witness that driver, that the plaintiff was traveling at a high rate of speed is fair game. And at least if the driver testifies as has been characterized by Mr. Hawkins, that is reasonable. That's a reasonable inference that an average layperson can draw from the circumstances presented to them. And so I'm going to deny plaintiff's motion in limine number 1, with the caveat that the point of it is they can testify about the fact that they perceived the car to be traveling, or the vehicle, I don't know what kind of vehicle it was, to be traveling at a high rate of speed. But speeding is a legal conclusion and we're going to stay away from that. Okay.
Thank you, Judge.
Anything else, Mr. Swan?
I don't know that this is going to be an issue or not, but it's probably worth paying a little lip service to. The motions eliminate related to our client's driving record. I won't hide from the fact that our client is not the best driver historically, but I do not believe that it's properly in front of the jury when we're trying to consider in this instance if he did something wrong.
Mr. Hawkins?
Yeah, Your Honor, I would concede that I do think it's relevant in this matter. The speed goes to the very heart of this issue. But to the extent that, the court would feel that'd be character evidence, I just added it to our witness list just in case a plaintiff gets up there and talks about how great of a driver he is. And right. I wanted to preserve that, for impeachment.
Yeah, I tend to agree, and y'all don't need me to tell y'all that. You obviously already know what the issue is, right? I agree that absent some specific circumstance that his prior driving history on other occasions, or the fact that he was previously cited for speeding, unless it's some sort of habitual thing that you would need to demonstrate to me, likely would not come into evidence. But of course, if he takes the stand and says, I'm the best driver ever and I never speed, then that would be a different matter. But for now, I think that as a general matter, motion in limine number 6 as to plaintiff's past driving record and citations is going to be granted absent. And typically the language that I will include is, absent a specific showing or specific circumstances that make it relevant or that otherwise make it admissible.
And judges, following up on that, the last one, number 8, is with respect to this incident. Our client was cited for failure to register his tags and not having insurance. And, while we don't dispute that, we just don't believe that that's particularly relevant to whether or not he did something wrong in the operation of his vehicle.
Mr. Hawkins?
Yeah, well, I think the reality is in this incident, he was the only person who actively was cited. So there's a few different parts going on. So this idea that, whatever's listed in the narrative that I would find you and cite you for this, I'd find you and cite you for that. So to the extent the narrative testimony, I guess kind of depends on some of the other motions that we had. To the extent some of that narrative testimony comes up, I thought it was relevant for that. And also the idea that, again, in this instance, he was the only person who was cited. And our operator was not ultimately cited. So it kind of was a mix of several other issues, but I think it's relevant because in this instance, he was the only person who was cited. He did receive a ticket in this instance.
Mr. Swan?
He was not cited for anything to do with the operation of the vehicle.
Right. So I don't believe that reference to the fact that he got a ticket, it's marginally relevant, but I don't think it's prejudicial. And that would be the basis to exclude it. And so to the extent that it becomes relevant by the way that the testimony is offered, I will potentially allow it. I don't think that it merits being excluded at the motion and limine phase.
Okay. Thank you.
So that one is count 8, or motion 8, I should say, is denied.
Thank you, Judge.
Anything else?
I think that's it for now. I think we can work through the rest of them.
Okay,
Anybody
excellent. So here's what I would like for y'all to do. On Wednesday, with the additional briefing that you're going to provide me as to the preventability issue, I would like the parties to submit a proposed consolidated omnibus order on all the parties' motions in limine. And I don't need them to be long and I don't need them to have argument, right? I just need to be defendants 1, granted, denied, reserved. If there's a title for it, so we all have some idea of what it is, that would be helpful, as opposed to just a number. But I don't need a whole lot of argument. I will add to it whatever I want to add to it for purposes of it being in Word format so I can edit it. You should mark that 27 as to preventability has been reserved. And then presumably that will allow you any of the ones that y'all cannot agree on, in addition to 27, just mark them as reserved. And then that way I will know that those are the ones that we need to agree on. To the extent that you are going to characterize in your motion anything about the way the order is written in terms of the motion in limine is granted, and so the parties are prohibited from, make sure that it is inclusive. The parties are prohibited. Because as I said, unless there's some specific or unique situational issue associated with one party, the answer is always going to be that if one party can't do it, the other party can't do it either. Anything else? And if you could provide that to me on Wednesday, the 19th, when you provide that additional briefing. And then that way we will be able on Monday, the 24th, to take up those specific evidentiary rulings that remain for us to resolve. Anything else?
John, I just want to circle back regarding how you said that accommodation may be allowed in terms of like scheduling for trial if we have to, skip a day based on when our expert is at the trial of the other matter that we talked about earlier.
Yes,
I just want to kind of figure out logistically how would that work, and when would we need to notify the court, or would that just be determined like on a day-by-day basis, since we know that he will be unavailable at some point? And again, we know about that calendar, so it could be one case or it could happen in the middle of the week, like our case may start. We're just trying to figure out logistically how that would work.
Well, basically, I'm just waiting for you guys to tell me, assuming that we start on Monday, at that point, as I think I saw, the subpoena is for that trial is also Monday. I think that the subpoena I saw was also for the 24th. Is that right, Mr. Hawkins?
That's correct, Judge, but similar as the subpoena we would send, I think the trial's that week. So
right, but so if they're picking a jury on the 24th, nobody needs him on the 24th. We don't need him. They don't need him. He is a defense witness here. I don't know if he's a plaintiff's witness in that case. I don't know how that would shake out. But I feel like once we know that the case is going to start on either the 24th or the 26th, that we'll have a better idea. Also have a better idea of whether that case settles, because, that happens. And so we'll have a better idea of the extent to which that expert is available or is limited. And so my point was, we can, if the plaintiff is giving their testimony, right, if their case is going to take 2 days, a day and a half, whatever, we don't need the expert then. And when it's time, when the defense has a clear idea of when their case is going to start and the order in which they might want to call that expert, they can bring it to my attention and say, hey, look, we were planning to call him next and he's not going to be available tomorrow. What do we do? And we'll work through that issue when it arises. But at that point, we'll have a better understanding of what his limitations are in terms of how long he's on hold and how much he's sitting there cooling his heels outside of a courtroom in Paulding County. And of course, the other thing, not requiring anybody to do it, and obviously you both have to consent, but Zoom is a thing. I've had plenty of witnesses. That board is as big as life and it faces right to the jury. And if they're testifying live, the parties can agree to that as well. So there are lots of ways that we can deal with it so that the defendant will still be able to put on their testimony. And when I do that, I always tell the jury, just like I would with a video deposition or whatever, that they are to treat the witness as if they are giving testimony live here in the courtroom, just like anybody else. So, okay.
And Judge, I'm sorry, one last thing. There is likely to be a use of an interpreter. Mr. Hassan does have a thick accent, and after review uniform rule 7.3, there just varies as to how different courts would like to handle that. Is that something that you want us to handle, provide? Is that something that the court has a preferred method? I just wanted to bring it up at this stage.
So we have interpreters on staff, although I don't know what Mr. Hassan's first language is. I'm certain we probably do, but usually those interpreters are reserved for criminal matters. And so I would likely expect that the parties would need to arrange for their own interpreter. But that interpreter would need to be someone, it can't be to the extent that Mr. Hassan, that interpreter needs to translate testimony, etc. It would need to be someone who has some independence, preferably a certification, but if they don't have a certification, some independence. Here's what I would suggest. There is a language and interpretation services office that is associated with Fulton County Superior Court. And they have a list of interpreters who are certified in various languages, and you'd need to make those arrangements, but they could at least provide you with someone that might be in a position that has that expertise and would have the necessary certifications. That's number one. Number two, I don't know how to do it, but since we're already in Zoom, I'm told that there is an active Zoom translation ability, not that Zoom does it for you, but that the translator could be sitting somewhere else and your client could be wearing headphones, listening to the translation in the Zoom in a way that doesn't disrupt any of our proceedings. That's number two. Number three is, as I have found frequently in my own practice and in court, people who function in, hey, if I was in France or somewhere and somebody had to take my deposition, I can probably order a beer and find the bathroom in Spanish or French, but I certainly wouldn't want my deposition taken in that language. I mention that because here's what I find frequently happens. The defendant understands, or the party understands what's happening and is able to say yes, no, whatever. You can't have it both ways, right? You need to explain to Mr. Hassan, if he's going to testify using the services of a translator, that he will need to sit there and wait for the question to be translated into the language and then answer in that language and then let the translator translate it and give the answer. That's how it has to work. Otherwise, it gets real wonky real fast.
Understood.
Anything else?
I think that's it, Judge.
Okay, well, thank you all for your time. I really appreciate it. And I am widely available. So if you have any other issues that arise, let me know. If you guys manage to settle the case, also let me know. I do know if the Lapido case goes, I am intending to have a final pretrial conference with him on Thursday. So I should be able, barring them settling at the last second, give you some guidance on Thursday if that case is still going forward, or at least by Thursday be able to definitively tell you they're not going forward, so you guys are going forward. But at this point, still be planning on Monday the 24th. Okay?
Yes, Your Honor.
Thank you all.
Thank you.
Yes, sir. Sure.
I'm sorry, can I ask one other question? For open, and maybe, I mean, if you want to take this up later, we totally can. For opening statements, you know, we'll have a PowerPoint. And what, do you have a preference on what can be shown in an opening statement, and what some judges say you can't show anything to the jury that hasn't been introduced into evidence? Other judges say, well, if it's been stipulated to, you can show it.
My understanding of the standard is that if you have a good faith, reasonable belief that that is going to come into evidence, that you can show it. Although I do require the parties to consult with one another about it. And what I find typically is that most of the time, everybody's going to agree except for maybe one document. And if that's the case, then I'm going to say, you know, what I typically ask you to do is consult, right? Hey, here's this big blow up picture that I'm going to show. And then they can tell me if they have an objection or not. That's number one. Number two, I often find that those issues are resolved when you do what I'm hoping you will do, which is get together and decide, is there a universe of 70 or 80% of your documents? Sometimes it's closer to 95% of the evidence in your case that everybody can agree is going to come into evidence. And if that's the case, then, you know, everything's available to you without a whole lot of discussion.
Okay, thank you.
Anything else?
Not from the plaintiff.
Well, thank you all for your hard work, and I will be in touch. I'll look forward to the order and briefing on the 19th. I will get your pretrial order on record today, and then we will go from there.
All right.
Thank you, Your Honor.
Thank you all. Have a good day.
Thank you.
You too.
Your Honor.